All rise. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Craig C. Valenti, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. You may be seated.
All right, good morning, welcome. The cases are going to be called in the order published. And by the way, we welcome any feedback. As you know, we've been going with Zoom, and some people like Zoom, some people prefer live OAs. So we give the litigants the option to do in person or Zoom. So if you want to leave some feedback on the website or send an email to the marshal, it's still a work in progress. I don't think the courts all over the country know exactly what they're doing. All right, to refresh your recollection, each side has equal amount of time. Helen gets to do a brief rebuttal at the conclusion, if you like, up to 5 minutes. Just remind me that's what you want, and I'll try to keep track. We're ready to go? All right. We'll take the first case, and that's the Sperling versus State of Florida.
Good morning, Your Honor, ladies and gentlemen of the court, opposing counsel. My name is Christopher Durashi, and I represent the appellant in this case, Mr. Benny David Sperling, and I'd like to reserve 5 minutes for rebuttal.
All right, I'll save it for you. I apologize, they changed clocks and this one's beeping. I gotta get it to your 20 minutes. There must be a mute button, but my wife knows what a mute button is, but this is on the back. Found the switch. My colleague found the switch.
There we go.
Lead it to a line and I'll let him judge. Okay, here we go.
All right, thank you. I'm not going to sugarcoat the facts on this one. This is a really creepy set of facts. I've got a guy who's taking a bank shot off a mirror and winds up taking a fuzzy photo of a girl in a bathtub with her breasts exposed and in a state of elation. But the rest of her is hidden under bathwater. And he's ultimately, one of the counts he's ultimately charged and convicted of is video voyeurism. And under the statute, at least the part they charged him under, the state had to prove that she was somehow privately exposing the body, which then you find out exposing the body is actually a term of art. It doesn't mean exposing the body, it means exposing a sexual organ.
But there's no definition of some of the key phrases.
Exactly. There's no definition of exposing, no definition of a sexual organ. So
But it does not say exposure of a sexual organ to another.
In fact, it says privately. And does the fact that the image didn't capture the exposure change our analysis at all? Because isn't the criminal act, unlike the Messner case, the criminal act here is the taking of the picture, not the exposure.
I would suggest the Mester case is a little different because
Agree.
Mester involves the other way that you can do video voyeurism, which is taking photographs of people in their, upskirt, undergarments.
No. Messner is the case I think that you relied on.
Oh, Matter. I thought you said Matter. Messner. Yeah, that was the underwear guy.
Right, and that statute was different. It used the term exhibit, and it's essentially the mirror image here of what we have. For the criminal act, there was the exposure itself. Here, the operative act for criminal charge purposes is the taking of the photograph. So does it matter that the exposure was private and that the organ, assuming that breasts are not sexual organs for purposes of this discussion, does it matter that the sexual organ was submerged, and why?
I would assert that the answer is yes, because first of all, for the video voyeurism statute, public exposure doesn't count. So therefore, the word private and exposure have to be mutually exclusive terms. So therefore, you have to expose it and it has to be in private. Okay. And the exposure in this case, well, as I said, ultimately we're all naked under our clothes. If we don't watch out, this becomes a really easy prosecution for the state, because.
But she didn't have clothes on.
Well, she was naked. She
had privately exposed.
She privately exposed.
She privately exposed her entire body because she was fully naked in a bathtub.
Correct. But did she expose the sexual organ? That's the issue.
Would you agree? Could just bear with me for a minute here. Private, we're just deconstructing these words, right? Privately modifies the exposed in this sentence. which contemplates that it wasn't intended for anyone else to see the organ. And the criminal act is the photography of that private exposure. So why does it matter whether the organ is captured in the image? Isn't the criminal act complete when the photograph is taken?
I would argue that particularly for this part of the video voyeurism statute, okay, that the real thing that the legislature is targeting is the harm of what's happening, okay? And in this particular case, certainly she was exposing the body, particularly from the waist up. Underneath, though, hidden by bathwater.
Well, isn't the harm, if we're going to look at what the legislative purpose was, which gets a little dangerous, especially since it's not expressed here, but isn't the harm the taking of the image when the victim has an expectation of privacy?
Certainly, and that paparazzi photo when somebody's dressed 3 layers head to toe in clothes, that could also be exposing the body too, because we're all naked under our clothes.
No, but the statute talks about private exposure of the body. It tells you what the body part is.
It's sexual.
I don't see it getting anywhere with the paparazzi picture with 3 layers of clothes.
Well, I have a question. Did you file a motion to dismiss or a motion to eliminate to flesh all these issues out? Ahead of trial, they just said, let it go to the jury. And then the judges start having to listen to all this. And he tossed some counts out. The jury found guilty on some, and I think not guilty on 1 count. So that the question is, was there a motion to dismiss or a motion to eliminate argued before the trial begins?
I don't believe trial counsel did that in this case. In fact, this actually came up as a supplemental JOA motion when they started arguing about the fact that, well, did she really?
During trial, you mean?
Correct.
No, the only reason I asked that because a lot of times it's strategy not to file such motion because you don't want to tip off the state. You got an ace in the hole. But if it's ambiguous, you kind of want to get those things out there ahead of time. Just asking, and I know you weren't the trial counsel, and the record's not going to reflect the answer. But so there was nothing filed ahead of time or argued. Okay,
Not that I was aware of.
your turn.
Thank you. Now, to address the points that have been made so far, we have to keep in mind that these statutes have to be strictly construed in favor of the defendant.
Is that so? When let's assume for a minute that the statute's not ambiguous. I believe that what our statutory mandate is with regard to the rule of lenity is where the statute's capable of 2 reasonable interpretations. We're required to apply that rule. And so you're assuming that the lack of definition renders the statute ambiguous? Is that, am I understanding your position correctly?
Not necessarily. In fact, I would probably say the fact that we're talking about how you actually expose, whether privately and exposing is mutually inclusive or exclusive, and whether or not merely being naked automatically exposes a sexual organ in the voyeurism. I mean, what if you actually view
Why
somebody
wouldn't it be a
naked from
jury question? If you don't have definitions, then the jury is entitled to use its common sense. And the jury deliberated pretty good here. You know, they didn't find guilty of everything. Even the judge threw some stuff out. The jury said yes on some, no on another. Generally, it goes to the jury, and once the jury makes a decision, if there's facts to support the jury's decision, we don't get to second guess that.
Well, and that's correct, but ultimately what we had here, it wasn't JOA, and there has to be at least some competence.
Well, you're saying that was an error. And you're saying as a matter of law, he cannot be convicted of any of these charges.
Well, with these strange facts, I would say the answer is yes.
Well, that has to be your argument, or you
Yes.
have no argument. Okay,
Yes,
I got you.
because basically the photograph at best shows breasts and everything else is hidden under bathwater. Even the court had to, even the trial court, when they were
So I
deliberating,
think
had
he
to
was
admit.
trying to take a video of. That's what was he trying to take a video of? He was a pervert. I mean, that's apparently the
Yeah,
jury believes
it's-
it's not up to anything wholesome.
Yeah, like I
Sneaking
said, it's
around
pretty,
it with the camera.
well, yes, it's a pretty creepy set of facts. I told you that up front.
You did, thank you.
But your focus on this, on the statute, you seem to be taking out the word private and making it a public exposure. The public exposure of the sexual organ would have had to be made publicly to Mr. Spurler. So your theory changes the statutory language.
I would say that in this case, the word privately, okay, it's an adverb. It has to be going towards the verb, which is exposing, okay? Privately exposing what? A sexual organ. Not privately exposing the body, because we already found out body means sexual organ. So the adverb modifier has to modify the verb, which is exposing, as opposed to publicly exposing, like you go out on the street to do it. People can take photographs of that, and that's not video voyeurism. In this case, I don't think anybody's arguing this was private. What we're based, this was private.
Nobody's arguing that it wasn't private.
Yeah, nobody's arguing that it wasn't private. What we're talking about today is what's really exposing, even if it's in private, what is exposing? Because you have to draw a line somewhere. And because apparently 3 layers of clothing, not exposing enough. Underwear, not exposing enough. Where do we draw the line? And we have.
But if you want to go that far, was the water clear or sudsy?
Well, apparently, according to the trial court, they couldn't see anything under the bathwater. That was one of the issues.
The image didn't capture, the camera didn't capture with clarity
Correct.
whatever was under the bathwater, which we know was the victim's sex organ because she was naked.
Oh, well, obviously she wasn't a eunuch, and therefore we get back to the concept: is the real standard of proof whether or not somebody's a eunuch? You know, if that's the only test, the state's going to have an easy charge with any video voyeurism, because every private event's going to be an exposure, and unless they're a eunuch, easy case.
I mean, it kind of sounds like your remedies with the legislature. You want the legislature to modify the law, or you want us to interpret the law as you believe it should be. And generally, the legislature, if they write a bad statute, they fix it. I have a feeling they're going to say it's fine the way it is, but I mean, that might be your remedy, and it isn't going to help you in this case. But
well, the state has to prove more than just this last piece. The state has to prove that the image was captured for the purpose of degrading or abusing. The state proved that here. The state has to prove that the image was captured at a place and time when the person has a reasonable expectation of privacy. Nobody disputes that this victim didn't have a reasonable expectation of privacy taking a bath in her own bathroom. So the only question is whether she was privately exposing her sex organ. And privately exposing is different to, for example, publicly exhibiting, which was the conduct at issue in Messenger. So I think your real hurdle is the private exposure. The crime here is not what he was able to capture on the image. It was the act of capturing the image when the victim had an expectation of privacy and had exposed herself in private.
And that's certainly a way of looking at it. Of course, we have argued a different way of looking at it, which is arguably another way you can look at the statute, which is why we now have 2 different ways.
Well, even if we get past that whole debate, your backup argument, right, is that her breasts were not a sex organ. And that too involves some interpretation because the term sexual organ isn't defined here. And in other contexts, the legislature has not been so precise as to limit the definition of sex organ to the victim's vagina. they have called, in other contexts, we have private parts. And the legislature specifically excluded breasts in the exposure statute. If they had meant to exclude breasts from the term sex organ here, they probably could have done that. So I'm just trying to get you to your second point so that you have time on that.
Right. And also likewise, however, in chapter 794, for example, when they're using union with a sexual organ of another, they also include and breasts. Because the legislature recognized in 794, breasts aren't sex organs. So they had to include breast to mouth because, well, people do that with young kids. It's kind of disgusting.
I don't want to
They
interrupt you, but
prohibit
you're
it.
coming up to your 5 minutes. Did you want to say 5 minutes for rebuttal?
Yes, I would.
All right,
Thank
thank you. Oh, okay. Want to clear this up for us, please?
What's that, Your Honor?
You want to clear this up for us?
Oh, yes, Your Honor. Good morning, Your Honors, and my name is James Hellickson, and I represent the state of Florida, the appellee here. Your Honors, this was a case, and the main issue here was the judgment of acquittal. And so when you look at the judgment of acquittal, you're looking at, do we have facts that are going to go to the jury, or can it be decided as a matter of law? And here, all that it was a factual determination for the jury. And I believe the trial court did everything correctly here, because when they initially moved for a judgment of acquittal, it was on intent. And there are.
You admit the facts. in
Correct.
favor of the state. Well, is there anything inconsistent with the judge throwing out 4, 5, 6, 8 through 12 as at the JOA stage and not these other charges?
Well, Your Honor, those specifically dealt with child pornography. And so I think,
Different charge.
yes,
different
and
elements.
here was the distinction there. So, and it applies a little bit to this, and it is a little bit relevant. So what they did was, as far as the pictures went, they looked at the pictures because there's undisputed evidence in this case that the victim was in the bathtub masturbating with a toothbrush, electric toothbrush. And so what happened was he captures this, and Mr. Sperling knows this is what happens. I believe he tells the detective, you know, I saw her, she was in the bathtub, her boobs are all hanging out, things like that. And they have discussions about what the images actually capture. And so what the trial court did on the child pornography counts is he limited the two where you can actually see her in a state of, for lack of a better term, orgasm. He said these are kind of the pictures that you know.
But that's sort of a red herring, because
Correct.
the victim's state wasn't, that's not part of what the state had to prove.
Correct, Your Honor, but that is why he granted JOA on those other child pornography counts and left the two remaining child pornography counts. And those really aren't an issue in this appeal, or on the but that was why those counts 6 through 8, I believe it was, were why they granted judgment of acquittal there.
So can we shift gears and
Yes.
sort of address your opponent's argument? In your briefing, it seemed to me to veer into territory that wasn't really at issue here, which was the constitutionality of the statute itself. I think the real question is, what does this, I don't think there's really a constitutional challenge here. I think is what do these words mean, and did the trial court properly interpret them for purposes of instructing the jury and denying the JOA? So your opponent's position, which it has some merit, at least debatable, is the image that was captured doesn't meet the definitions within the statute of what the state was required to prove on private exposure of a sexual organ. Can you address that?
Yes, Your Honor. So you are correct that it's not really unconstitutionally vague, but that was the discussion at the second argument for judgment of acquittal, was that the sexual organ part, you know, wasn't defined and that it wasn't exposed.
So you were preemptively briefing that.
Well, what I wanted to show, Your Honor, was that in order to be unconstitutionally vague, it has to be, you have to have more. And what I wanted to show was that this statute has a standard. It's not completely standardless that you're going to capture, as he was mentioning, you know, you're naked under your clothing. That's not what the purpose of the statute is. It has a very narrow focus. And if you look at it, you know, this child was completely naked under the bathwater. You know, her whole body, as a trial court found, was exposed. You know, it doesn't need to define, you know, a specific sexual organ for purposes of the video voyeurism statute. It does not. Because what the video voyeurism statute, if you look at the entire statute, is it's looking to protect victims in certain states of undress. Is the privately exposing the body comes after dressing or undressing. So it's protecting the victim in their private moments when they expect to be having these things that they're not expecting to be photographed or recorded. So if you look at the dressing, undressing, and then privately exposing the body, which means exposing a sexual organ, that's what they're getting at, is that they want the victim's actions to be kept private. And so it does not create.
What's the criminal conduct that is prescribed here?
Yes, Your Honor. So the criminal conduct that's prescribed is that you have to meet several elements. One is an unconsented taking of the photograph. Then you have to have the taking of the photograph with the intent to use it for one of those enumerated purposes, either amusement, gratification, entertainment.
And,
like that.
let's contrast it for a minute with child exploitation
Sure.
images. Is there a requirement that the image has to capture? Where, help me out here. I think your opponent can meet this on rebuttal. I don't see in the statute a requirement, which I think is different than some of the child exploitation pornography cases, that the image itself has to be pornographic or otherwise capture a private part or sex organ of the victim.
That is correct, Your Honor. And one of the cases that if you look at the first district's decision in Allen v. State, I know the facts are a little bit different and they have a little bit more evidence there because there's some Williamsville evidence in there. But if you look at that case, they don't even have the photograph. And one of the statements that the court makes is, if you look at the gap between when the offense occurred, when he was arrested and when they searched the phone, there was ample time for him to delete the photograph. So in that case, they don't even have the photograph and they still find that the video voyeurism count is permissible. Now they look at some of the Williamsville evidence there, but in that case, they didn't even have the photograph. There was enough testimony to establish by him trying to kind of maneuver the phone, excuse me, Your Honor, under the dressing room door and record her as she's changing, that was sufficient to meet it. So yes, Your Honor, you don't need to necessarily capture the person engaged.
So if I reduce to simple terms, your argument is the image itself is largely irrelevant to the state's burden of proof of the elements for this crime.
So it would matter to some extent because you obviously have to look at, I think that kind of would distinguish between if you're looking at the completed crime versus the kind of an attempt to do it, because I think if you, like in this case, he did capture the victim.
He had to have an image.
Right,
But
and
the
he
content
captured
of
her-
the image didn't matter.
Correct. And so like in this case, he captured her, exposed upper body. And that was gonna be enough. It didn't have to show her, as a child porn. It did not have to depict child pornography or an exploitation. It just had
But
to.
your opponent's position on that, and you can address this now, is that since sexual organ isn't defined in this statute, but is defined elsewhere to be limited to that vagina or other parts, not including breasts, that the fact that all that is captured in the image, at least for purposes of being able to see what was going on, is the victim's breasts, and according to your opponent, that's not a sexual organ. So can you address that?
Yes, Your Honor. If you look at the way I'm kind of drawing a blank, but they defined it, or that it applies here, is that the victim needs to be doing one of those, required things, and then that was what in the picture needs to be taken. So I think in this case that they properly had the discussion about what a sexual organ was when they were discussing the judgment of acquittal, and they discussed, in the sexual battery context, it is limited to penis and vagina. And I think here what the trial court found was that she was completely naked in the bathtub.
So she had privately exposed.
Correct. So even if you could take out the fact that the breasts were exposed, her whole body was ultimately exposed in the bathtub. And I think, in this particular case, you have both, completely exposed. And so I think that they discussed the proper, they had the proper discussion during the judgment of acquittal, and then it was properly sent back to the jury with the understanding that as far as sexual organ went, that the jury could use their common understanding of that term. They didn't have to craft a specific definition of that.
So your position is the statute is not ambiguous. So we don't ever get to principles of construction like the rule of lenity.
Correct. And Your Honor, that's, if Your Honors don't have any other questions, that's really the case was, it really came down to the judgment of acquittal. And the state would argue that that was properly denied and the case was properly submitted to the jury. And we just asked the court affirm.
Thank you.
We asked the court affirm the judgment.
That means your time wasn't up.
But I didn't, I just.
You don't have
wanted
to use it all.
One closing comment is that the broader you get under this statute, the less likely the conduct will fall under this statute, because you're likely to fail on one of those elements. Like if you were to say, well, someone's walking down the street and you take a picture, you're probably going to miss the privately, they were in a place where they had a reasonable expectation of privacy. And so I think the broader you get, the less likely this statute is going to apply. And with that, Your Honors, unless Your Honors have any further questions, I just ask you to affirm.
All right. No, thank you, Mr. Ellison. All right, brief rebuttal.
Thank you. The one thing I would offer in rebuttal is that if this is truly an unambiguous statute, then we have to accord these words their plain and ordinary meaning, which exposing normally means bring out to plain and open view.
Except that it's modified here by privately, and and context is everything.
Sure.
We start here with where the image is going to be captured to make it a criminal act, and it's in a place that the legislature has specifically defined where the victim would have a reasonable expectation of privacy, specifically including but not limited to a residential bathroom. So in that context, your argument would make a lot of sense if the legislature also hadn't included the term privately to modify exposing. But I have a hard time in this context accepting your position with the words that the legislature put here.
I understand. I would also posit that there's a reasonable expectation of privacy in automobiles. And there's a surprising number of folks who drive nude, and SunPass takes lots of photos of drivers as they go through toll booths. But they only take the headshots, not below. Is that video voyeurism? Because they're privately exposing their naked.
Do you have a reasonable expectation of privacy in your car? I mean, we're not confronted with that question today,
I
but to
understand.
answer it the way that you would want us to, we'd have to conclude that. And the statute, unlike a residential bathroom, doesn't include an automobile. Probably.
It's an interesting thing. I think the legislature originally started with body, and then because it's weird how they did this to start with. They used the word privately exposing the body, and then all of a sudden they defined exposing the body as exposing a sexual organ. It's almost as if they thought one thing and then all of a
So
sudden.
if we say
decided-
privately exposing a sexual organ, we still have, and that's, I think, a fair read of this subsection D, we still have the privately part. And the context here of don't take pictures of people when they're in a place where they should reasonably be expected not to be photographed, like their bathroom.
I would assert that, yes, this is a place where you have a reasonable expectation of privacy, but at the same token, we've only made certain things in video voyeurism illegal. And I would assert that in this particular case, this is a strange set of facts. Usually we don't have this situation. Usually in video voyeurism, they're exposing their sexual organs. It's plain.
Or you're having an upskirt.
Yeah, or it's
I mean,
photos of
no.
an department store. It's plain. This is very different because everybody, even the trial court agrees, her lower part of her body is obscured by the bathwater, and it's a really fuzzy photo. Thank you.
Very good, thank you. With that case, we'll move on to the next case, which is Heron versus State of Florida. Have a great day.
Thank you, Your Honors.
Yes, Your Honor. Thank you. I please the court, Mr. Hurley. Good morning. My name is John Fitzgibbons. I'm a lawyer in Tampa, and I represent Cameron Heron in this appeal. I would like to reserve 5 minutes.
All right.
Your Honor. Thank you.
You got it. I have a question, preliminary question. You broke your argument into 3 issues in your brief. Are you going to argue 3 issues separately, or are they kind of overlapping to some degree, at least issues 1 and 2?
Your Honor, the first 2 issues are the significant issues, the disparity and the abuse of discretion. The 3rd issue, we don't feel is as important as the other 2. The other 2 are interrelated.
Because disparity of sentencing could be part and parcel of downward departure justification, right?
Yes.
So I'm not necessarily, I don't think there's a bright line separating those 2 issues. I just didn't know if you wanted to bring that out to my attention so I could focus on each issue separately, or you don't have a preference.
I think that some of the facts are going to relate to both, and I'll try to
That's fine.
do my best. Thank you, sir. This is a horrible case. There's no dispute about it. There's nothing good about it. It's tragic all the way around. The events in the case took place in about 30 seconds on a May Day in 2018. The 2 young men were stopped at Bayshore Boulevard and Gandy, and 30 seconds and maybe 1 or 2 or 3 more later.
Mr. Fitzgibbons, you did a fabulous job briefing this. And
Pardon me, Your Honor?
you did a fabulous job briefing this and arguing it in the trial court, and we've read the
Thank you,
record
Your Honor.
and the briefs. So I have a question for you that ties a little bit to what Judge Valenti asked, and it is, I reviewed your arguments.
I have a little trouble hearing, Judge, sometimes.
So
I'm
sorry, let me
Get to
yell
a
at you a
certain
little
age
bit
here,
better.
it's,
Can you hear me a little bit?
Yes,
better now?
thank you.
Sorry about that. I reviewed your arguments pretty much separately, recognizing that issue 1 is a predicate to issue 2. And with regard to issue 1, right, the downward departure, you've got a very difficult standard of review there, such that the bottom line question is, is there no reasonable trial judge that would have refused to downward depart? I would like to focus on issue 2, just assuming, that it gives you a legal predicate, the fact that I'm sorry, the fact that there was a disparity. And so what I think the fundamental inquiry comes in under Sanders, right, was the trial court is justified in departing on this only if the record establishes beyond a reasonable doubt that this defendant, that Mr. Heron's culpability was no greater than that of Mr. Barano, right? And which leads to the same problem that I think you have with issue 1, and this is where I'd really like you to address the points. Isn't the trial court's determination of the answer to that Sanders question a discretionary determination? Each case stands on its own facts. It's a judgment call. It's the Fernandez case committed to the trial court's discretion. And your opponent has argued that they weren't equally culpable for, I think, 4 reasons, having to do with the black box data, the fact that Barano was 17, and that Mr. Heron's car, through random or into, however it did, Mr. Heron's car is the one that actually had contact. So can you address where the trial court legally erred in refusing to downward depart on the basis of disparity?
Your Honor, I think you have zoomed in on the key issue here. the equal culpability of Mr. Barano and Mr. Herron. And we think the court respectfully got it wrong. And for a number of reasons, because I think that drives so much in this case. First of all, the state, the judge did not give a lot of reasons in his, when he was pronouncing his decision. He seemed to rely very heavily on the state. And I even brought along a couple of the state's comments that they said during the arguments. Your Honor, we're here today because of the actions of Cameron Herron and quite frankly, Cameron Herron alone. Main argument, which is the most obvious, Barano did not strike the two people. I can't stress it enough. I don't know why it's so difficult to comprehend the difference between this defendant and Barano. Cameron Herron killed them. His vehicle struck and killed him. But I think that that ignores the facts that we tried to develop in our brief. Two young men started out together.
They're drag racing.
Pardon?
They were drag racing. This is a form of vehicular homicide where it's almost presumptively, they're intertwined, obviously.
Inextricably intertwined. we believe.
And the evidence is what it is. We have one witness who says that Mr. Barano's vehicle was in front and that Cameron's vehicle that he wouldn't have been able to avoid. I forget the witness's name, Lewis, I think. And then we have some other evidence that seems to contradict that. So these are all evidentiary determinations that the trial court is making. And I'm just going to jump on the side for a minute here, a little segue. I was surprised based on my own research and the fact that nobody briefed it, to learn that there is no proportionality downward departure case, and you tell me if I'm wrong here, involving drag racing vehicular homicide sentencing, because they're always going to have two defendants at least. And it was a surprise to me that for as long as the statute's been on the books, we haven't had this case in the state of Florida. Am I right about that?
Yes, Judge, because we spent a lot of time looking, thinking the exact same thing. It just seems so normal that this would have occurred on different occasions.
And that puts us back, and I'm sorry, I don't want to beat the dead horse or use up all of your time, but I think that brings us back to what our role is, reviewing what the trial court did. And our role is limited to trying to find a legal error with the presumption that the trial court acted correctly and the evidence supports that decision. What did the trial court do here that constituted an abuse of its discretion in deciding that these two defendants were not equally culpable? They're based on evidentiary factors, admittedly narrow, but we've looked at the whole record, which is very well developed. And the trial court, there's a view of this, and I understand the empathy and sympathy in this case on both sides, but there's a view of this that the trial court was empowered to and did exercise his discretion to resolve these evidentiary differences and conclude that these two were not equally culpable. And I think that's the case law that we're confronted with. So help us find a legal error, or what you say is the legal error.
Your Honor, I don't think that the evidence was that contradictory. As the young men drove up Bayshore Boulevard, different people at different stages of the way observed things. Sometimes Mr. Barano was in the lead, sometimes Mr. Herron was in the lead. The state charged this, they arrested them together, they charged them in the exact same information, they charged them with racing. The state could have charged Barano with racing alone and not vehicular homicide. They chose to put them together, and the Puccio case talks about the state's theory. That's been the state's theory in that particular case. That's been the state's theory all the way, that the two of them are racing. And I think that what Mr. Lewis said is there's just no dispute that at one moment, Mr. Barano's ahead, he sees the woman and child, he cuts in front of my client. As Lewis said, my client had to go around him, and boom, and then unfortunately it happened.
So maybe one of the most compelling aspects of your argument on this point is that the trial court accepted when you went through the plea colloquy or the colloquy at sentencing, that the trial court used one set of facts for both sentence, to accept the plea for Barano and to sentence your client. And that argument has some appeal since the trial court, that gives you a place to argue that they were exactly the same. Talk to me about that.
You're right, Judge, because we did have the, as we put in our brief on this, that the plea colloquy, we went first. State read the stipulated factual basis. We agreed, and then Barano comes in right after us, just via Zoom, and they don't even read the stipulated facts. They stipulated that we agree what was read previously.
And your opponent, who will address this, is likely to say, well, we were at the end of a very long, emotionally charged day, and we're on Zoom, and the facts are the facts, but that doesn't necessarily mean that there's equal culpability. I think that's what it.
Excuse me, the plea took place on December 31st, and Barano was sentenced on the spot pursuant to his agreement with the state. Everybody there felt 6 years is fine. Then our sentencing was several months later.
Did you ask for a PSI at that point?
No,
The judge ordered a PSI on his own accord or her own accord? There's reference to a PSI in the transcript, but we don't actually have the PSI.
I don't remember seeing one, Judge, and if there was one, and I'm sorry for that, we knew all along this was a mitigation case. We just did.
Well, so my question is on your first issue, at least, if you proved mitigation and there was a legal basis where the judge could have downward departed, but then the judge has to do this weighing process under the case law to decide if that downward departure is the best sentence for this particular defendant. So my question is, if you prove downward departure grounds exist, are you saying the court's obligated to downward departure at that point, or they still engage in that second step and do the independent analysis?
Well, we would argue that we set forth, this is the abuse of discretion argument, the first one, that we presented. I know abuse of discretion is a very big hurdle to get over. There's no doubt about it. But we felt we presented enough that when we look at the definition of abuse of discretion, and they talk about the Huff case and the Banks case talk about logic and justification as part of the definition of abuse of discretion. We just think with everything we presented, it was not logical to give one defendant 24 years, not depart, and another one 6.
So this case law you allude to comes from death penalty cases, where there's co-defendants, felony murder, things like that. And they generally, there's recourse if they don't get the same sentence. But you don't have any case law to say you have that same right to the same sentence as another co-defendant. I see distinctions here. I mean, I was a trial judge for a long time. If the state comes up and says, we got a plea negotiation on party A, and you give me the facts and I can see the distinction, well, someone's left holding the bag. In this case, it was your client. He didn't get that benefit because obviously the state refused to give a negotiated plea to the person they felt was more culpable. And the facts on the record, the judge said, geez, you make the contact, he was speeding at was 170 miles an hour the night before, the day of. It doesn't show, and you have an alleged adult, 18 years old versus 17. So there's enough for the judge to hang its hat on in approving plea bargain A and not going with the downward departure. Same reason the judge didn't have to give YO. I don't think there was a request for YO in this case, was there?
Yeah, there was, yes.
The judge rejected out of
Yes.
hand, but that's not part of your appeal.
And that was one of our grounds for departure.
Okay.
And Judge, I think it just boils down to this issue of culpability. We just don't see daylight between the two young men in this case. If the conclusion is there is a big difference in culpability, that's one thing. But this could not have happened without both of them in concert.
Well, here's the other thing that's a little bit confusing. Straighten me out on this. This is a vehicular homicide case.
Yes.
That emanated from drag racing.
Well,
Street racing. Why would both people have to be charged with vehicular homicide if only one made the impact?
because I think that the state's theory here was to join them together because they were concerned about certain things, one being that the impact speed was below the speed limit. And so they wanted to get the racing in there, I believe, so that, to help their case. And I keep coming back to the culpability. Their theory was, it was two individuals racing along, and the woman is struck. The only difference is at the last second, the other guy veers in front of my guy, and it happens. It could have been either one of them. And that's equal culpability. It seems that they charge them again as
Reduced to
conspirators and strictly.
You just passed your 5 minutes. I don't know if you want to save that for rebuttal or if you want to come back and keep
I could
going.
talk for a long time, so I'll say.
Everyone could. Okay.
Thank you.
Thank you so much. I'll save you 5 minutes. Response?
May it please the court, Jonathan Hurley, with the Office of the Attorney General, representing the Appalachian State of Florida in this case. Your Honors, real quick to bullet point this. There was no error in the process that the court applied during sentencing when it comes to following banks. Number one, there were 6 issues, bases asserted in their motion for downward departure. All 6 were recognized as legal bases by the court.
And 5 were accepted as proven.
5 were
And
accepted,
the disparity
1
was
was not. But from a standpoint of, let's analyze was there legal error? First of all, the court recognized all 6. When it comes to the one that it did not, the disparity issue, the appellate would argue that the record supports the trial court's finding that the evidence was insufficient to reduce this sentence from the lowest, from the LPS, from the.
So I think your opponent has conceded that that's sort of a throwaway issue here,
Well,
issue 3. But stay with me. One of his arguments, and let's start at the top with issue 1, is that the trial court did abuse his discretion, among other things, because it was the trial court found, and I don't think there's any serious dispute, that 5 of the 6 bases were proven, were met, and disparity was the open question. But if I understand his argument on issue 1 correctly, it is that alone sets up a good argument for abuse of discretion, because you have 5 out of 6 mitigators for downward departure, and the trial judge blew past all of them and denied it. Can you tell us why that wasn't an abuse of discretion?
Well, to respond to your comment that the court blew right past them, I think if you read the record, I don't think
I
that's.
did read the record.
Right, and I think the trial court painstakingly went through the totality.
When I
of
say blew
circumstances.
right past them, Mr. Hurley, what I mean is, he didn't, forgive me for a misuse of that term, he disregarded them in his decision-making, even though it's a significant quantum of mitigators, 5 out of 6. And your opponent's position is that was an abuse of discretion. If you've got 5 out of 6 and 1's in question, he should have granted a downward departure. This is issue 1. Abuse of discretion is a high hurdle. He's saying it meets that hurdle. What's your response?
With all due respect, I don't think the court ignored those first 5.
Let's say, you're missing my point.
Yes.
I'm not suggesting that Judge Nash ignored anything. What I'm suggesting is that everybody agreed. Nobody questions that 5 of the 6 mitigators in question were met. 1 was in question. It's certainly the subject of a legitimate debate. And nonetheless, the trial court didn't find a basis to depart. And is that an abuse of discretion? I read this record. I know that this judge took it seriously. We're taking it seriously. The state took it seriously. But the question now is, was that an abuse of the trial court's discretion on this record? And tell me why it wasn't.
It's not, and the reason it's not is because the court, again, is looking at all the aggravating and mitigating factors. And this is a judgment call. This is a subjective judgment call. As long as the court does its weighing and examines the record in totality. And yes, there were mitigating circumstances that you referenced to, Your Honor. There was also aggravating circumstances, which
Well, weren't
the record.
those-
So the
weren't
weighing
those-
process
Wait,
is a judgment
then
call.
you've taken us right to issue 2. And weren't those aggravating your opponent's position clearly is that the aggravators, as you called them, aren't they present across the board equally in both of these defendants' conducts leading to this crime, this end?
Some of them may be, but there's also distinguishing facts and circumstances between the two co-defendants. If you, again, going back to Sanders, the record has to show beyond a reasonable doubt that they're equally culpable in this case. Just looking at just reading the transcript of the plea hearing, you see that there's debate in essence, even though, again, this is the plea colloquy is justifying the charge. It's not settling who is more culpable in this case. It's not saying, okay, plea hearing, we've decided they're both equally culpable. That's not what happened here.
So that's your point to respond to using the same colloquy for both to accept the plea and then as the basis for
the colloquy supports the state's position. The fact that on the record, which was not objected to the colloquy, you've got 2 eyewitnesses. First of all, there's no question they're racing. There's no question that they're alternating positions of who's ahead and who's behind and so forth. Okay, that seems to be.
They're both endangering the pedestrians and other drivers on
And then to answer
Boulevard.
Judge Valenti's question, why was it a vehicular homicide? Vehicular homicide, you drove recklessly, and because of that driving recklessly, you caused the death.
And they
Okay,
had-
causation, so that can go along with that. Doesn't mean you were equally culpable. That just means you caused it, and your cause could have been this far, and this person's cause could have been up here,
Well,
and that's enough to get for the
The
crime.
question of death penalty cases. The death penalty have aggravators and mitigators, usually decided by the jury, sometimes the judge. And one aggravator can outweigh 100 mitigators. I mean, I don't see.
Yeah, and in this case,
numerosity is a factor here. It's the aggravator versus the mitigation.
Well, right, it will to the point of whether or not it was whether or not it would have been proper to depart downward from the lowest permissible sentence, that is the culpability, the record has to show equal culpable. In this case, you had evidence by 2 eyewitnesses that said, no, the defendant was ahead of the co-defendant just prior to them being hit. Okay, so you have a discrepancy even within the plea colloquy. You also have video evidence which was shown just prior to the hitting that the judge got a chance to review. The judge looked at this video. The judge heard the colloquy. And the biggest thing of all, of course, is when it comes to are they equally culpable, is one defendant hit the victims, the other one didn't.
And
So-
your opponent's position on that, I think, and this is my extrapolation, not his, but this is my read of it, is that in the passage of another 15 seconds or the shortage of 15 seconds, it could have been either of them. It was just a question of how the events transpired in the time that they did, where they were on the road. Barano was in front, Barano was in back. And the way you charge these defendants, it took both of them to commit the crime. So this was just a random happenstance of timing and logistics, effectively, not something that would distinguish between their culpability. That's what I think is a key aspect of your opponent's position. So, and that's what he's saying, I think, that the trial court, where the trial court abused its discretion with regard to essentially issue 2.
Well, whether the issue is what does the record show beyond reasonable doubt, not hypothetically what could have happened. That's not what we're debating. We're debating what does the record show, and that's what the state is presenting, that they were not. The record supports that court's finding that they were not equally culpable. In addition to that, they weren't similarly situated. Sanders says that they both have to be equally culpable and similarly situated. The glaring difference here is, at the time of the offense, the co-defendant was a juvenile.
But they waived youthful offender for him on the plea bargain, didn't they? He was not sentenced as a youthful offender.
He, as part of the plea, but.
He was charged as an adult.
He was
right?
charged
He
as an
doesn't have the
adult,
option for life.
but the court, but the co-defendant could have pre-negotiated, and in addition to that, this was a negotiated guilty plea by the co-defendant. That unto itself is a legal basis for departure, which the defendant did not have a right to. So that's another distinguishing fact between the two. But the whole context of the juvenile versus adult, you know, the focus on the juvenile sentencing, frankly, is on rehabilitation. With adult, it's punishment. So pre-cooperation with the state by the co-defendant, they could have requested the court use its discretion and apply downward sanctions. Absolutely, they had every right to do so, not by the defendant, maybe youthful offender, but not juvenile sanctions. That was not an option for the defendant. It was for the co-defendant. It's a totally different situation. But even, you know, argumentatively, if you want to say, well, they're equally culpable, it's still harmless. This court still had the pure discretionary determination whether or not it should depart in this case, even if the court accepted all 6.
Another judge, similarly situated, for lack of a better term, could have gone the other way. But this judge, who was on the ground, looking these people in the eye, looking at all the evidence, this is what he decided to do. And your position is that that was well within his discretion and proper under the guiding law, most specifically probably Sanders. Am I right?
That's correct. And to your point about whether or not there was racing, was there any case law on racing in departure? I couldn't find any case law strictly on this purely departure. Is there ever a case where a trial court was reversed on a purely discretionary review?
Well, that
and under should have
that's
under
another
bank
interesting
step 2?
question.
No.
Just an aside type question. So if the judge did downward depart, you wouldn't be filing an appeal because there was a legal basis.
There was a legal basis.
And you're stuck with that. I mean, usually downward departure, if a ground doesn't exist, the state can appeal that and get a reversal, but not if a downward departure ground exists and you don't like the sentence.
It was a subjective call, the judgment call made by the trial court. That's not reviewable. This was not an abuse of discretion in the context of the court somehow didn't apply did not apply its discretion from a due process standpoint.
Well, that's where mixing issue 2 and 1, if you separate out the second issue and say disparity of sentence, then that might be an abuse of discretion. I just don't know of any case law other than death penalty cases where you have a right to equal sentencing.
Your Honor, the Supreme Court of Florida no longer even considers proportionality. The Lawrence opinion, Lawrence versus State, 308, 3rd, 554, 2020 case, the Florida Supreme Court no longer considers comparative proportionality of the sentencing as part of its review. So the Supreme Court doesn't even recognize proportionality review anymore.
So that's kind of your response in a nutshell to issue number 2?
Well, to number 3, for sure. Excuse me, to number 2. If you're saying, well, if the argument, with all due respect, to me, it wasn't clear in the initial brief where this proportionality argument is coming in, but I can only assume that looking at the case law of proportionality analysis, the old proportionality analysis, that was the last step after the court reviewed aggravators and mitigators. Then finally you get the proportionality analysis under the 8th Amendment, which has now been taken out. But besides that, you could, I guess, the argument is that, okay, they're not equally culpable. However, they're relatively culpable or comparably culpable. And in that case, the court should have applied a proportionality analysis and so on and so forth.
But again, that was factored in in the sentencing, the judge didn't give out the maximum sentence.
No,
It's a
no.
mid-range sentence.
The judge is within the guideline sentence. The lowest permissible sentence was 18.5, the statutory max was 30, the trial court
Well, that shows that really
gave 24.
the abuse of discretion didn't really exist, because maybe an abuse of discretion would be just the maximum without consideration for the disparity in conduct.
If the court didn't do its job
Does it make
and
a,
apply its discretion, the court just simply said,
Does
you know what, I'm dying with these vehicular homicide racing cases, throw the book, and I'm gonna go look at it. That, of course, would be.
does it make a
abuse of discretion.
difference? Does it make a difference to your analysis that the other mitigator, or I think most of the other mitigators, not all of them, are statutory? And this one, this disparity, is judge-made law. Does that in any way change your analysis? I'm going to ask your opponent to address that rebuttal.
I don't think so.
Because what
what
made me ask you that question is or maybe brought the question to my mind, was your argument that the Supreme Court no longer recognizes proportionality,
Right.
which, take that out to its logical conclusion, this body of judge-made law could be eroding before our very eyes as a mitigator at all.
Well, again, without going too deep into the weeds of proportionality, which is kind of moot at this point, again, proportionality analysis is distinct because you're going beyond weighing aggravators and mitigators in this case. Proportionality now, you're reviewing, geez, in all these supreme death penalty cases, let's take a look at the situation because death is different. Right? We don't have a chance, an opportunity to downward depart. You're either getting life or you're getting death. And so from that's why there was a proportionality analysis on the Eighth Amendment and so forth. But it doesn't really apply. First of all, it's gone. It's not longer considered by the Florida Supreme Court. In addition, here, that's not really an obligation what the court had to do. The court had to look at the facts in this case and weigh, which the court did painstakingly in the record, the aggravators and the mitigators in this case. We're dealing with 102 miles an hour on Bayshore Boulevard, 11:30 in the morning. Everybody knows Bayshore Boulevard, what goes on. I'm sure everybody's walked Bayshore Boulevard, bikes. It's just gotten more and more packed over the years since when I used to live on Bayshore Boulevard. That was egregious to go that kind of speed on that particular. We're not talking in the middle of some rural road out in the middle of Polk County somewhere. We're talking right on Bayshore Boulevard. Second, the impact, the victim, the harm in this particular case, the mother,
Egregious.
an infant. I mean, the whole family's wiped out. So to say that no reasonable juror would rule the way this court ruled, the court just, I mean, the state just doesn't agree with that. Questions?
No, thank you. Mr. Fitzgibbon, I've saved you 5 minutes.
Thank you, Your Honor. One or two factual comments. Number one, we believe the videos help us a lot. There were videos from several residences along Bayshore Boulevard. They're not the best, but what they show are the two cars going and they're like zoom, zoom, right behind each other. The detective, homicide detective Jakes, testified that the Nissan at all times was during these times was right behind the Mustang. They were very, very, very close to each other at the time of impact. If you have one of these things you see on NASCAR where they have the arrow pointing at the car and the distance between two cars, you'd have 1 second. We've done time and distance measurements. They're like a second behind each other along the way here. And I just do not see the difference in culpability. If that is the aggravator being that my client struck the two people. But I just don't see how within a second or two or three, it could have been the other. Two peas in a pod, two cars driving together. And that's what turned everything that the state has said and the court in its limited reasons is my client's car struck the people, the other car didn't. Therefore, night and day difference, 6 years here, 24 years here. you know, they had to nail somebody here really bad, and we know that. And that is, my client was the scapegoat because at the last second, he's the one that hit. Verno would be up here making the same argument, I suspect, if the rolls had been a couple seconds later. Also, when it comes to abuse of discretion, when you look at Huff and Banks, you know, the Supreme Court talks about that discretionary power is not without limitation. And the test requires a determination of whether there is logic and justification for the result. And I think in this instance, where we prove 5 out of 6, where the judge said, I agree with you. You did it. You did it right. And then disparity was the only one he didn't agree on. That's a lot farther than most of us have done in many, many, many cases. But I just don't see the daylight here. And to give this young man, you know, death is different, I agree. But to give this young man, 20 years old, 24 years in prison, he had just graduated from Tampa Catholic. He's never been in trouble. No alcohol or drugs involved in this case by anybody.
Well, let me ask you a question. Would your argument be the same if the co-defendant got 24 years in prison also?
Well, it
Did
was,
the other person get off too easy, or your client got way out of proportion? I assume you're focusing on the latter.
yeah, that's a hard one to answer. I mean, I would probably say,
I'm just saying that takes your thunder away.
well,
Maybe they
except that,
screwed up in the first case.
but the state felt the 6 years was entirely appropriate for,
It was a negotiated plea, and the court approved it. So the court obviously approved it. But you're not here on that case, so I don't want to.
and the court was, I mean, the court was going to approve it. There's no doubt. And it was, they wanted my client, and they reached the agreement with the other one, knowing that we were going to plead anyway. I mean, it
Well,
was,
was there part of the agreement that the other client, the other co-defendant would be required to testify
Well-
if your client chose to go to trial?
technically yes, but really no. He wasn't going to testify. They never listed him as a witness. He and the
You see
debriefing.
what I'm saying, though? That's another factor that no one's really argued. We assume that's a factor because he pled out. He doesn't have a Fifth Amendment right at that point.
It's a smokescreen, Your Honor, because as we understand, we got a Brady statement that they did a very quick debrief, they being the state of Verno. Verno said we were not racist. And they weren't going to call him in 100 million years. And it was a kind of strange proffer. The prosecutor went over to the defense lawyer's office. The police officer, Detective Jakes, didn't even know about it. It was window dressing. That's what it was. It was window dressing.
You're down to about a half a minute. I don't want to stop you, but.
Well, I guess the point I would like to make as much as I can is that there's no daylight, like I've said a couple of times, between these two young men. If they're equally culpable, and I believe if they're equally culpable, then this sentence of 24 years versus 6 is excessive. And
Thank you. Thank you.
if I could conclude, Judge, with one comment. I've been privileged to practice this profession that I've loved for over 45 years. This is the case that keeps me awake at night and always will. Thank you.
Well, thank you for telling us. Take the next case. If I mispronounce the name of the next case, I apologize. It's Radu versus Crasium and Nicoletta versus Russo. All right. As soon as they clear out, you can come on up. Get situated, get comfortable, put your papers down. You'll be going first. You know that, right?
Yes.
Okay. You want to start?
Yes.
Okay, good, I guess. You know the rules, right? 20 minutes.
Yes,
And you want some rebuttal time, up to 5 minutes?
I would like to reserve.
All right, I'll let you know.
Yes. Thank you. May I start? and the members of this channel. Good morning, everyone. Further, I'd like to thank you for extending me the privilege to be here in front of you today. My name is Radu Creation. I'm a pro-se litigant in this appeal today. The appeal case number 2D213005.
Do you mind speaking up a little bit louder? Because when you put your head down, I can't hear you.
I'm sorry.
Maybe it's me, but it could be the microphone.
Could be, yes. I might need to stay closer to it. Again, my name is Radu Creation. I'm a pro-se appellant in this case matter today. Appellate case number 2D213005. Honorable Court, first I want to draw your attention to the fact that Ms. Rusu and her filings of this appeal, she has concentrated her efforts in the entire 35 pages of her answer brief to attack my character and to make numerous unfounded allegations and assaults against me. And she took another 10 pages and her motion to dismiss my appeal to do the same, instead of staying with the facts in this case if she had anything truthfully to say. So, in the due course of my oral arguments, if time allows, I'm going to answer her false allegations and insults. Honorable judges, I strongly believe that based on the laws of this state and based on the precedent of the appeals court of this state, I presented strong arguments in my briefs that the lower court committed error after error in this case matter, entering ex parte emergency order on August 4, 2021, to alter the provisions of the final judgment. Further, not scheduling a timely hearing on my motion to dissolve the emergency order. And further, holding a return hearing that was not timely noted. And at the time, the court was aware that after August 20th, I was infected with COVID and under the powerful medications, which was remdesivir. I took the shots of remdesivir and brought me back to life. My mind potentially, my mind been altered by the medications and by the illness. More, talking about the return hearing didn't have anything to do with any emergencies or any best interest of the minor child, as we can read in the order. That return hearing, my belief is that was strictly about just setting me up and discussions about the car incident 6 months prior, as one can simply understand reading the order on return hearing entered on September 9, 2021, and subject to this appeal. Nonetheless, Ms. Russo's emergency motion to suspend father time sharing that she filed on August 4 failed to outline any immediate irreparable harm to the minor child or any risk of the minor child being removed from the state, because there was none. As one can read in Ms. Russo's emergency motion. Also, her emergency motion failed the certification to what efforts have been made to contact me for the hearing, or otherwise state why I should not be contacted for the hearing. And I can list some cases, similar cases, as 100 versus 100 and so on. But by the virtue of time being very limited, I'm going to move on. Even more, Honorable Court, I rightfully invoked res judicata on this appeal, as Ms. Russo had no contact with me for over 10 years since we separated in 2012. I'm not her drinking buddy, and she doesn't know any true facts about my life since we divorced. On page 5 of her answer brief, she's fantasizing something might have occurred in 2009 of my life. Even she fantasizes to something 21 years ago on page 13, about half page under the argument of her answer brief. In 2009, even 21 years before she filed her emergency motion, as she argues as she argues in her answer brief. I believe she didn't even know that I exist and where do I exist. At the time, I believe she was living in an ex-Soviet Union republic. Now, by my experience visiting those republics, some of those republics, Soviet Union republics, I know how they tell the truth, and the people here, how they tell the truth, what they think about America. And my belief is that Ms. Russo inherited a love to gossip. and she found audience in the lower court in Denver. Since we divorced, Ms. Russo hardly could ever see me from a distance during the exchanges at the police station, where we do the exchanges during my visits with my son. And we do the exchanges at the police station for the very reason to protect myself against the avalanche of false allegations and assaults. In over 3 years, I didn't even talk to her. Even during court proceedings, we were under COVID restrictions and we were doing Zoom. To make a story short, a legal question of law: how can possibly Ms. Russo claim all the insults and allegations she made towards me are true if she never had contact with me in all those years? I didn't talk to her over 3 years. She's not around me, and I never had a drink together with her for the matter in over 10 years. She never filed any motions claiming that I abandoned my child, nor my motions that the child was ever abused by me, as she falsely claims not in her answer brief and her motion to dismiss my appeal. To answer these questions, this question of law is that Ms. Russo perjured herself. And I believe perjury does come with the provisions.
Mr. Crescion,
Yes,
you were at the hearing where that resulted in the order that's on appeal. Is that right?
we were through Zoom.
Through Zoom.
Yes,
And did you tell the trial judge then that you were suffering from COVID or that you were on medicine?
I did more than that. I sent 2 emails to
Before the hearing?
before the hearing and after the hearing as well. There are 2 emails. I have evidence of the emails sent to the court.
The emails that I've seen in our records seem to have been after the hearing. And so that my question was, what did you do before the hearing?
If my memory helps me, I did notify the court before the hearing. And during the hearing, I did state my position, and I was not offered the opportunity.
And unfortunately, we don't have a transcript of that hearing.
Right,
You know that,
unfortunately, yes, we do. We do not, by the fact that I was not going to get a court reporter, and the hearing was not timely noted. And the premier of being able to hire a court reporter, and also I have those emails to the court reporters who said if I'm wrong, if the emails or if the email that I'm referring to was after the hearing, but for certain during the hearing I did make my position, and I was not offered this opportunity. The only opportunity I was offered during the hearing was to enter a fifth, because they were beating me or beating the horse, excuse me for my expression, on the whatever happened to 6 months prior to that incident, which this case is not about that incident. It's strictly about a minor child that his rights have been abused. And I believe the lower court committed error after error in this case matter, as I presented in my briefs. If I may continue, the second legal question of law is how my child was affected by the fact that I was involved in the fender bender accident beyond my control. While the mother admits that my child was not present, and I never missed any visit with my child following that incident. The answer to that question is that no one was affected, including my child. The entire motion, emergency motion, was based solely that I was involved in some sort of accident 6 months prior to the filing of the emergency motion, where basically the car was taken as a deadly weapon by overzealous cop. And that's another story. Now, Ms. Russo, she waited 6 months after the incident to file her emergency motion. And it would only make sense, she could have waited for a regular scheduled hearing if she believed she had a case. What was her emergency? I explained extensively in my briefs that there was no emergency, as outlined in Gersonich versus Gersonich. We do have on file the record and the attachment to her emergency motion, claim as verification. The record of the incident, she referred to 6 months prior to her filing of emergency motion. The record is a public record nonetheless. And I didn't see anyone saying anything about mental issues or alcohol issues or any hang-ons. However, her so-called verification does not equal affidavit, the affidavit required by the laws of the state to contact me for emergency motion hearing, or otherwise state why I should not be notified of the hearing. She never logged any complaints that I'm aware of whatsoever to authorities or to court that I might be a criminal, drunk, mentally incapacitated, impulsive anger, or otherwise that I have ever displayed any sort of mental or physical abuse towards her or towards my son Alexander, or displaying any weapons whatsoever, as she falsely claims on page 25 of her answer brief. I ought to believe I would have been arrested if any of the above would have occurred, and with no doubt she would have told this honorable court about my arrest. I'm going to skip some paragraphs I have here, and I might come back to that. Nonetheless, this case today, it is not about any fender benders incidents. It is not about any handguns or cannons. In this case today, it is not about any belts, as Ms. Rustos refers in paragraph 9 of her motion to dismiss my appeal. Rather, this case here today is about a minor child, that his sacred rights have been abused, his visits with his father got unreasoned or suspended, and in fact, this case is about an error of the lower court that is to be corrected. And Ms. Russo's bells, as she refers in page 9 of her motion to dismiss, will be honoring here in this honorable court. My visits with my child needs to be restored as soon as the discretion of this honorable court dictates, at the minimum as per final judgment. As now the summer break is coming up, I would kindly ask your honorable judges to order a make-up time for the visits lost between August 4th and May 11th, 2022. As follows: 41 dinner visits lost for 3 hours each week, totaling 123 hours of dinner visits lost, and 20 weekends visits lost from Friday 3 p.m. to Monday 7 a.m., equaling 64 hours each visit. I added them together, I came up with a total of 1,403 hours, which translates to 58 days and 11 hours. This is the total days I have lost visiting with my child based on the mother fictions. I would suggest that during the summer break, my child stays with me and the visits with the mother, and he visits with his mother in the reverse order as my visits were. In other words, every other weekend and every Wednesday, until we catch up with the time. After that, we go back to the regular time sharing as per final judgment, or as the further modifications calls for. I believe this is a fair schedule and serve the best interest of my child. Now, if the time allows me, I'm going to tell you a little bit about me. On the contrary to her filings, to her insults and allegations, false allegations. One thing she's not telling you what I do in my life, that I'm an active member in good standings of Romanian Orthodox Church, Clearwater, where my child is visible every Sunday, he is with me. She's not telling you this fact because she doesn't know any true facts about my life after I divorced her. And my son is not telling her what we do together. And because Ms. Russo doesn't know anything about my life after I divorced, she's making up untruths, and her imagination runs wild. Bringing insults on page 26 of her answer brief, and I can start with some people are inherited bed, whatever she's trimming out there. Now, just reading next paragraph on her page 26, she's telling us what her intentions are, and she's telling this court, this is an emergency situation that can be cured once and forever. Full and complete termination of father visitation rights with minor child, except for telephonic communications initiated by the minor child. Ms. Russo, in fact, is telling us what she hides behind these false allegations. She's asking this honorable court to set aside the law and abuse my child's sacred rights.
You're coming up to your 5 minutes. Do you want to keep going, or you want to save the 5 minutes?
I'm going to save my 5 minutes.
All right, we'll save it for you.
Thank you, Your Honor.
Ma'am, you want to argue?
I don't have anything to add.
Nothing to add? Okay. You got your 5 minutes.
Yes,
Keep going.
thank you. Honorable Court,
basically what Ms. Russo is asking this court to give her my child. So he further gets punished with and not having any contact with me. Even during the phone conversation, the phone visits with my child, the only thing my child is coached to tell me, I don't want to talk to you. And that's what he has been telling me for approximately 2 years now. I have provided my child 4 phones over the years, but he cannot use them because mother takes them away because he talks to me. He's using the phone to talk to me. Honorable court, my child only spent 1 week in his 11 years of life visiting with me for extended period of time, which was 1 week by the virtue of Honorable Judge Henson that has extended his kindness, and he put trust in me, and I took my child to the Smoky Mountains. Otherwise, during the weekend visits, we hardly can reach Miami on very rare occasions. At no time the mother ever logged any complaints following this case. Judges, Ms. Russo's pictures worries me a lot. And at the same time, at the time when she's contemplating suicide and murder, and she has custody of my son, that worries me a lot. Honorable judges, I can assure you I'm not mentally incapacitated in any way. And she is admitting in page 5, 6, and 13 of her answer brief. I have never been found mentally incapacitated, I'm not suicidal, and I have no intentions to harm anyone. I want to assure you, I have no alcohol issues. On the contrary to her allegations, I do not use any alcohol at all. In fact, I inject myself 5 insulin injections every single day. And I wear a monitor, the monitor just turned down a little bit. I had to put the kid in my mouth, my sugar running low. So I'm injecting myself insulin because I want to live. I don't want to die. And I want to carry on my duties as a loving father for all my children, and I want to see my children grow up. I don't use any alcohol as opposed when I was married to Ms. Russo. My 32 years since I live in America, I never had any DUIs, I never used any illegal drugs in my entire life. I never have been found mentally incapacitated in any form. I never used a gun against anyone, and I was never been convicted of any wrongdoings in 32 years I live in this wonderful country. My criminal record is crystal clear. Honorable Court, you have today in front of you a 56 years old man and a loving father who takes pride in all his children. More, I am a loving father to all my children equally, wherever they are, including the 4th child that I have adopted from Morgan, previous marriage. The child has witnessed the death of his ill natural father. And based on my stepson sharing with me, I don't wish any children on this planet to ever experience such departure and separation from his father.
You got about a minute left, so you know. So choose your last minute the way you want.
Honorable Court, I would like to introduce to you my wife, Olga. Please stand up. I'm married to her for 7 years, no problem, no issues. Other than what Ms. Russo is making up. I want to emphasize that Ms. Russo emergency motion that she filed is not supported by any facts and not supported by any laws of the state. She admits on page 8 of her answer brief that the minor child was happily visiting with me at the time she asked the court to suspend my visits. And even after she was empowered with an order suspending my visits, she allowed the visits to continue. And I returned my son happily living to the mother, as always. She failed to make any reference to her and her emergency motion of any immediate irreparable harm to the child because there was none.
I don't want to interrupt you, but you're out of time. So
Thank you, Your Honor.
I want to thank you for coming. Thank you for coming.
Thank you, Your Honor.
Hope you both have a nice day. We're going to call the next case. That's John Shim, MD versus Cruz and Chronister Sheriff of Hillsborough. Ready to begin? Both sides ready?
Yes, Your Honor.
Yes, Your Honor.
Good morning, Your Honor. May it please the court. My name is Patrick Brennan of HU Law Partners, and I have the privilege of representing the petitioner in this matter, Dr. John Shim. I'd like to say 5 minutes for rebuttal.
All right, you got it.
Wonderful. This petition for writ stems from the trial court's ruling. Essentially, what the issue is Dr. Shim's, who is a non-party, his privacy right to his finances. In particular, there was a motion for protective order that was filed on behalf of Dr. Shim in the underlying case. Senior Judge Herbert Bowman on September.
Let me ask you, how he has privacy right when he throws himself into the controversy by the expert?
And that's not necessary, and I respectfully disagree with the categorization regarding him throwing himself into.
But it's highly divided.
Well, no, and I think there's in the Elkins case, it's clearly recognized that there's still financial rights to privacy. And looking at Florida Rules Civil Procedure 1.280, which was adopted after Elkins, clearly says an expert shall not provide financial, and I can read it because it's.
I've seen the rules. I've gone through this. I'm trying to figure out how to extrapolate his income, given the question he is being required to answer.
Certainly, and this is, in a practical sense, this is what happens. In this case, which is also in a practical sense. So there is a rate sheet or a fee sheet that's provided under the rules of civil procedure. And that rate sheet itemizes obviously whatever his charges are for deposition, trial testimony, compulsory medical examinations, medical records review, etc.
So wait, we've got it. What's the difference between this discovery? How many times, average time, how many CMEs on average does he perform a week versus the percentage of time he spends, the rule authorizes? What's the difference?
And that's a great question, Your Honor, and there is a difference. The percentage, and that's what I proposed to the trial court.
Well, isn't the extrapolation analysis the same? Because that's really what your case hinges on, isn't it?
Not in part, Your Honor, it does. There's an extrapolation in terms of multiplying just the number of CMEs.
Right, you can do the same thing with the percentage factor that the rule authorizes.
Arguably.
I mean, it requires maybe 3 calculations instead of 2, but what's the difference?
And so the difference being is you don't know, obviously the percentage of CMEs that he performs on an annual basis is less invasive. I think the analysis has to be a less invasive analysis. The percentage of CMEs that he does in relation to the percentage of the income that he derives from performing the CMEs on an annual basis protects the actual numbers. The numbers is what is being accessed.
But what you deny the other side, if I take your theory, is you are denying them an opportunity to explore bias, because according to you, he doesn't have to tell them how many, what percentage or anything. The rule allows that, and isn't the other side entitled to know how much time does he spend as an expert for a particular party?
Yes, Your Honor. Under the rules.
But you're telling me that if he can't answer that question, I'm taking away a tool of cross-examination of the expert.
Not at all, Your Honor. And I think where the balance has to be made is what is reasonable. And Elkins goes into a very well-detailed opinion by the Florida Supreme Court detailing that, hey, we've got to put up some parameters protecting these non-party experts. And that's exactly what the Elkins opinion does. And so, protecting these non-party experts from overly invasive and burdensome discovery requests is what the purpose of Elkins has been and what the subsequent case law has developed into. And so we're not preventing them from exploring bias because you still have the discovery from Bosher, a party. This is discovery from a party to a non-party. Bosher versus Allstate is a party to a party, and they get the information.
But the breadth of the discovery in Elkins was significantly different. We're talking tax returns, incredibly invasive financial discovery. This is at best a tool to extrapolate.
Your Honor, I respectfully disagree. I believe you're putting together a puzzle. There's puzzle pieces that are going into this puzzle, and you're looking for a number of CMEs to calculate what his gross financial income is from expert services, which the rule says you clearly cannot do, and Elkins says the same thing.
Well, the rule also says you can establish bias through cross-examination based on a financial interest. And which is why, and I don't think Elkins has a whole lot to do with what's going on here. It's easy for me to understand why the information in Elkins would be protected under the constitutional right of privacy. It's not so easy for me to understand. And that's your burden here. You're on a certiorari. You have to show irreparable harm that can't be remedied on preliminary appeal and a departure from the essential requirements of law. And even if we assume, for purposes of the analysis we have to do, the existence of the first two prongs for jurisdictional purposes, the essential requirements of Elkins is not an essential requirement of law that would apply here because of the quality of the discovery. But the rule of civil procedure is an essential requirement of law, and it authorizes something very much like this. So that's where I'm struggling with your case, and I'd appreciate you addressing that in the context of our certiorari jurisdiction.
And Your Honor, and I think the focus is the departure of the essential requirement of law is if you look at the ruling, and you look at the order, there is no analysis. There is no identification of the.
Well, the trial judge can rule, there's no requirement to provide an elaborated order here. I mean, we're presumed on this part of the review to be capable of analyzing what the trial judge did legally.
And Your Honor, looking at what the trial judge did in this case is he failed to identify any kind of compelling interest between the need for the discovery and.
Well, wait, the trial judge had a big long hearing, talked about this, and the transcript is long. And while it concerned other matters, I think it's an unfair description of what the trial judge's boots on the ground analysis during this hearing to say that he didn't do any. The fact the order, I assume, was a prevailing party, whoever that your opponent prepared the order, let you look at it and the judge signed it. But to say that because this is an unelaborated order, the trial judge didn't do analysis, which is what I think you're saying, is belied by this record, in my opinion.
And Your Honor, looking at the analysis, looking at the trial judge's reasoning, I quote to you, his basis for the order, bias is always an issue. And that is that, in his opinion, the number of CMEs is a legitimate issue to ask an expert who's going to testify. And that's at page 69 of the appendix.
And does that depart from the essential requirements of law? Is that your argument?
Your Honor, it does. And looking at
It's akin to what 1.280 allows. So if the question is, what percentage of time you spend doing these, you have no problem with that.
well,
Or you're going to tell me the privacy right trumps 1.280.
well, the privacy right is, there's a constitutional right to privacy in addition to a privacy right that's been recognized by the courts that's been adopted in 1.280. And so both of those do apply to this situation. And in looking at it, it's an approximation of the expert's involvement as an expert witness, which may be based on number of hours, percentage of hours, or percentage of earned income derived from serving as an expert witness. Now, the difference is, and my colleague here in opposition states that the question of, it's a very similar question to the number of hours that petitioner spends in a week acting as an expert, which is a part of the above rule. It's not, but there's a difference because Dr. Shim does not charge based on the hours he's performing these CMEs. He charged per CME. So it's a distinguishing factor between what the rule allows for and versus what how he bills. So he doesn't bill per hour. He doesn't say, okay, well, CME is going to take me 1 hour and my hourly rate is $11.50.
Well, let's come back to the rule because you've agreed that the rule applies and we're looking, you need us to find a departure from the essential requirements of law. And what the rule says is the expert shall not, it says what the expert can be required to disclose in the way of pieces of the puzzle, as you called it, going to the bias issue on his finances. But the last sentence of the last clause of the rule says the expert shall not be required to disclose his or her earnings as an expert witness or income derived from other sources. If the trial judge had ordered your client to disclose his earnings as an expert witness, which the trial judge did not, then we would have something to talk about as a departure from the essential requirements of law. But all this trial judge required your client to do is something, then we've beaten this horse, very close to, and perhaps the same as, and your opponent's going to tell us why it is, but the percentage of time he spends serving as an expert witness, which to me is a lot like how many CMEs do you perform a week?
And I disagree because of the fact that.
Because couldn't you ask your client how he spends the rest of his, if he does 18 CMEs per week and they take an hour each, how many hours a week does he work? What else is he doing? You know, I mean, that gets you the same place the rule gets you.
Well, and I don't necessarily see it the same way because it's the percentage of the time that he dedicates to performing CMEs, and then that still has the same effect as soliciting the same bias information that they're looking for.
Which is the information that the rule allows them to.
Yes, Your Honor, and I agree with that. And so what I disagree with is having a finite number or an approximation of the number of CMEs that he does. You take that, what his rate sheet is, because they're entitled to know what the compensation is that he received in these cases. You already have a deposition trial testimony list. You know how much he charges for a deposition. You know how much he charges for a trial. All you have to do is say, okay, well, how many CMEs do you perform? Boom. You put all the pieces together and there it is. That's what his expert financial income is.
But that's not what the rule precludes. The rule doesn't preclude that. The rule precludes disclosing earnings as a general proposition, which is, I think, what was, and I think it was designed to remedy and prevent future occurrences of the Elkins scenario. But
well,
how much money he makes as an expert is fair game for impeachment.
I disagree. The rule says the expert shall not be required to disclose his or her earnings. Earnings as an expert witness.
In gross.
Yeah, that's what he. But
the expert can be allowed to, and the trial court can require the expert to disclose an approximation of the portion of the expert's involvement as an expert based on number of hours, percentage of hours, or percentage of earned income, but not in gross, which I think is designed to address the constitutional protection in general, as opposed to the specific need. It's a balancing.
I understand that, and looking at the balancing right, I would argue that the constitutional right to privacy, in addition to the right to privacy that's been recognized by Elkins in the Florida Rule of Civil Procedure, trumps any collateral issue, any impeachment information that they would otherwise obtain that has the effect of soliciting his finances. And looking at the Lind case, which is a 4th DCA case, and it clearly states in Lind that it's the number of hours an expert performs, expert work, private expert work in a given year, and the hourly rate information has the effect of disclosing a non-party medical expert's finances. And it's looking at that 4th DCA case, looking at that, this has the same effect.
That's your best argument here, right? Lind controls and establishes the essential requirement of law from which the trial court departed.
Lind in part recognizes that financial right to privacy for a non-party medical expert.
I assume when you do CMEs, I'm assuming the doc knows in advance that there's going to have to be a disclosure of his rate for procedure. Is that fair?
I think that's a fair conclusion.
So one enters the business knowing that this is going to have to be disclosed.
Well, I think in part, the hourly rate information, what you're actually getting paid is going to be disclosed.
You know that going.
Well, I think over the years, if it's
part of the deal.
If a doctor is customarily involved in those matters, and they become involved, they become aware of that. Yes. So
it undercuts privacy argument, doesn't it?
Well, not necessarily. I understand that argument. I think just because they have a knowledge of what the hourly rate chart or what those rate sheet will show, I don't think that's necessarily to assume a waiver of a privacy right.
Mr. Brennan, I don't want to interrupt you, but you told me You wanted 5 minutes for rebuttal. If you stop now, you'll have 5 minutes, or you can keep going if you want.
I'll
Save it.
I'll save it. Thank you, Your Honor.
In this court, my name is Brian Lee. I'm representing Robert Cruz in this appeal. I want to go back to just and what the court already knows. Obviously, we're on a petition for search warrant. And so we're looking at a specific issue. We're looking at the question that the trial court allowed a plaintiff's counsel to ask Dr. Shin. We're not looking, or at least the court is not looking at what becomes after that. There's a lot of speculation that I've heard or that you've seen in the petition itself as to, well, what can you do with that information? Can you ask these questions after? Are those questions relevant? Are those questions things that the trial court can do? That's not before the court. The trial court has the ability under discovery, which is what this is, to make those determinations as to what is discoverable and what's not. And under the certiorari standard, obviously the court knows we have to. Has to be irreparable harm and has to be against the essential requirements of law. We don't believe they get to the irreparable harm part, Your Honor, is because of the fact their whole argument is that, well, it's irreparable harm because it deals with the private finances of Dr. Shin. It does not. The court's already looked at the rule. I would submit that when you look at Elkins and when you look then at the rule that happens, the court in Elkins, obviously, as we put in our brief, had a question almost exactly like this one. The district court decided that question was proper. That was the one they were going to ask. Was it going to allow all the taxes? Was it going to allow all that information? But it was going to allow that question to be asked. And the Supreme Court said, we agree with that. Now, it didn't find its way into the rule, but did it? I think it did. Because what the rule says is that not only can you get an approximation and hours percentages, whatnot, but you can also find out what the expert has done in that particular case and what is the compensation for that service. That's the first part.
So your opponent's best case for a departure from the essential requirements of law does seem to be the application of Lind. Could you speak to why Lind didn't bind the trial court and whether that was a departure from the essential requirements of law?
Sure. Lind was a per curiam opinion.
I don't think that matters.
Pretty
It's a
short
written
one,
opinion.
but yes, but what it required, and I'm looking at my response here just to make sure, what it required, or excuse me, the order in Lind was quashed because it required the expert witness to disclose the number of hours in 1995 for private expert work and hourly rate information. Okay, so they made it. Now we don't know the context behind that decision because it doesn't really give you the facts or thing, but the fact that they're putting in there that it was for private expert work, that means something, at least to me. It means that the court was not saying this is expert work that's through litigation. Obviously, Rule 1.280 contemplates litigation. That's what they're there for. And so the court in Lind, at least what we can see from the opinion, the trial court was going beyond that. Was going to not just what you do for litigation, but what you do for your quote private expert work. And that is, I think, Judge Rick, you were talking about that. You were saying that there are different things that experts do, or that we would qualify as experts. They do work for litigation. They could do work, frankly, for litigation that never sees the light of day. They could be a consulting expert. They could do other things. They could do records reviews. They could be called as a treating physician in a case. And so, which may clarify them as expert work in some sense. So what the court is saying in Elkins, what the rule is saying, is that that part of your work, that is what expert litigation work, that's what they have the opportunity to get to, the plaintiff or the defendant. Again, Elkins talks about it that it's both ways. You do it both ways. And so when we're talking about what exactly the trial court rule, even if you get beyond the irreparable harm part, we don't think there is any irreparable harm, because if it's not private financial information, there is no irreparable harm. They can't point to anything else that this would cause irreparable harm to Dr.
Well, it would be really hard for them, I think, on a plenary appeal if the jury, you can see where this goes for the appellate argument on a big verdict, right? So.
Sure, and I think ultimately it comes down to the reasoning for it. The trial court in the hearing, and it's very clear. I mean, I would suppose that I know this trial judge. This trial court knew what he was talking about. He had seen this before, and he talked about bias as being something literally that is on every single witness in front of this courtroom, and especially on an expert witness who has injected himself in litigation. And that's what he based his opinion on, is that it is bias. There is nothing that you've heard, and frankly that you can't hear from the petitioner on that, because bias is obviously something that is under there. What you're hearing from petitioner is that, well, because he said an average amount of CMEs, well, then that means that he's really getting into this financial information. It is not at all. It is akin to the amount of hours that the rule specifically says that a trial court, not even a trial court can allow, that the rules allow. And so even if you get to the essential requirements of law, the trial court followed the law, period. He allowed essentially what the rule says you can allow, bar none for any other cases that were in front of him, he allowed them. And so when you get to the point of looking at this, what Dr. Shim is wanting this court to do is extrapolate CME different than what the rule is. What he's wanting you to do is he's wanting you to take one question that the trial court allowed and then say, well, because of all these other questions that could be asked, that you should find you should file, or excuse me, you should grant a petition based upon that. I've never seen this court do that. I've never seen any court do that, because you can do that on every single case. If I was allowed to come in and say, well, the trial court is going to allow this witness or this officer to talk about the observations that he made at the scene, well, I want a petition for a search warrant, because he can then ask them, what do you put in his report? I mean, you're going down the road of what you could use information for that the plaintiff, Mr. Cruz, was absolutely entitled to get, and how that information is going to be used. This court doesn't need to worry about that, because that power goes to the trial court. You haven't heard anything about what the information was used for. There's nothing in there. And so the trial court ultimately has the ability to not only allow discovery, to grant or deny a motion for protective order as the court sees fit, but also how those parties are going to use that information. That's what the trial court has. And in this record, in this case, there is nothing to show that this trial court departed from any essential requirements of law. In fact, he followed it. I think I may have some more time, but unless the court has any questions for me, I'll rest on that.
Okay, Mr. Brennan, you got 5 minutes.
Thank you, Your Honor. And just to recap, I understand this is on a petition for writ, so those 3 elements have to be met. This is a non-party. Dr. Shim is a non-party, and non-parties don't have a right to appeal. As seen in the Katzman case, Price versus Hannes, which is a second DCA case, and the Head versus Barron 1B case, which was cited in our reply, second DCA. With respect to number 2, resulting in injury for the remainder of the case, I understand the general rule is it cannot be speculative. I get that. However, here, this is the cat out of the bag type discovery, which was recognized not only in Katzman, but
Well, let me back you up real quick. I don't want to use up all your rebuttal, but I get the part about non-parties can't appeal. Then that would be a good response with respect to the constitutional issue, right? For purposes of certiorari and irreparable harm. But here, the real harm from this bias, aside from whatever constitutional interest, and we've talked about that already, would be the impact on the defense or on the plaintiff of having this expert's financial circumstances put to the jury associated with his expert work. And that's going to be tough on plenary review to turn into a reversible error, isn't it?
well, Your Honor, I think the material injury is to Dr. Shim. I think we have to look at in terms of Dr. Shim.
I hear what you're saying, but I wanted to see if you acknowledge that there is another part of this that would be relevant or could be relevant on plenary review and why it could lead to irreparable harm or not.
I understand what you're saying in terms of with respect to the parties' positions, but Your Honor, I'm not following maybe entirely, so. But in looking at that, and looking at those cases, this falls under the exception. Dr. Shim is injured by the effect of having to disclose his finances. Looking at the Lind case, the trial court did not follow the law. This is an essential departure from the law. Looking at Lind, the 4th DCA case, which is applicable to the trial court, which would have had to have been recognized, some balancing interest. And looking at all the case law that's been provided, there's got to be some balancing interest, and you don't see that in the record. It's not in the record. It was argued to the judge, and it was explained to the judge. Use the percentages of CMEs that he does, or the percentage of his practice that's comprised of CMEs. That's a fair question. Getting his gross financial numbers from running the calculations, that's not, it's just not, there's no need for it. It's a collateral issue. It's based off of impeachment only. This has no relevancy to the underlying pleadings, to the allegations contained in the complaint, or the affirmative defenses that have been raised by the defendants. It's solely a collateral issue, and to allow the court to expose Dr. Shim's or have Dr. Shim's personal finances disclosed and potential for use and further injury to Dr. Shim, I think the trial court got it wrong. And looking at that case law, looking at 1.280, Your Honor, I don't think I have, there's a couple of cases that did further recognize that the stating that requiring a non-party expert to state the number of patients for whom he performed disectomies for, and this is in the Katzman case. Katzman was recognized as a hybrid, so he was a fact and an expert witness. They recognized that in that case, that computation stated the number of patients for whom he performed disectomies in each year and the amounts received during those years from a health insurance company versus his letters of production. That went to the underlying issues because it had to deal with the reasonable necessity of medical expenses. We don't have that here. Dr. Shim's charges for the CMEs aren't in dispute, and he's not a fact witness. It's clear that he falls under 1.280, those protections and the protections that have been iterated in Elkins. So, Your Honor, I don't have any additional information. I just thought it was quite telling in the Elkins case, requiring an expert to lift his visor so the jury could see who he was, what he represented, and what interest, if any, he had in the results of the trial so the jury could appraise his credibility, does not encompass the emptying of one's pockets and turning them inside out so that one's financial worth can be open to scrutiny. So here, Your Honors, I respectfully believe that that's exactly what happened with relation to Dr. Shim, and I'd ask that this court quash that order for the reasons iterated in the petition and the reply.
Perfect timing. Thank you both. Folks, before we call the next case, which will be the last case, we're going to take about a 10-minute break and then we'll come right back and do progressive back on track. We'll be in recess.
All rise.
Okay.
We'll be in recess for 10 minutes.
Yeah, I didn't, they used to do that and then I just heard that they're, they do it by San too, and I'm like, oh, should this all?
I know, that's what I heard saying, that there was kind of a mixed bag, so I saw that.
Yeah, I think what they've done, which I just didn't do because I had other stuff to do. But I think what they do now is when they do the notice, there's an argument, they actually put in there that if you want it, I said, you want to push. And then both parties can figure out whether yeah, so I just the way you said it. Yeah, I'm going towards I'm seeing a couple of people there. But yeah, I think you were a long time ago.
If you're on the last case, you can set up.
I hope you have a sense of firm or reverse. Yes.
I know someone just went to the RP that built one for that same drive.
Oh, yeah.
So not yet, but he said it was. He said she was on board with the position. So
With your position.
yeah. Although
That occurs, we'll be doing it again, so.
Although I've seen some other defense firms block quoting in the for the war arguments and citing the video as if it was sort of an issue. During for the war, just for the safety council admitted that we need to. We have to submit it.
What did they say, what did they say?
Then I didn't, I can't, it's just.
You were already.
Yeah, well, you can pay a different methodology, but that somehow means that our condition, that the general statement is being cited, like it was like all state. And I think 705, I think we can't argue the issue anymore. And I was like, I don't think you understand what I said.
It's just 57.5 aggressive period.
All rise. This court remains in session. You may be seated.
Okay, welcome back. Thank you for queuing up. We're ready to go.
Yes, Your Honor.
All right, let's proceed.
It's in the afternoon now.
Yeah, sorry
No,
about
not
that.
quite.
Oh, we're not behind schedule too terrible.
Good morning, Your Honors. I'm Ken Nazari here for the appellant Progressive. I'd like to reserve 5 minutes
Okay, you
for
got
the
it.
vote, and may it please the court. We're here today on a PIP suit that involves a dispute that's been come to be known as a build amount dispute. And there's a reason it's called a build amount dispute, because what happens in a build amount dispute, what happened in this case is a provider such as Back on Track, a chiropractic clinic, issues bills to the PIP insurer for treatment of an insured, and the insurer, in this case Progressive, accepts the charges that are issued in full, doesn't reduce them, doesn't deny them, doesn't take any issue with them, and pays 80%, which is the PIP coverage.
And that's for the policy.
For the policy and for the PIP statute, because 1A is the coverage mandate, that's non-disclaimable, fundamental, 80% of all reasonable expenses that are also compensable. So you ask yourself on the face of it, where's the controversy here? They built this
Well,
amount.
the controversy, right, comes from the Geico cases.
Correct, and I was going to frame that.
And we
yes.
can kind of get there.
Okay.
Because you all have favored us with an exhaustive record and extensive briefing, and we've read all of it.
I was going to get right to the controversy. So here's the controversy. The controversy is, their position is that merely, in this case Progressive, merely by adopting what's known as the scheduled maximum charges as a cap, as a maximum limitation on the amount of reasonable medical expenses, Progressive and any other insurer that does it, thereby commits itself to paying all medical
Yeah,
services.
the cap becomes the floor, essentially.
That's right, essentially. You have to pay all medical services at the cap. I'm sorry, please.
And the Supreme Court told us in the State Farm MRI case that it's a cap, not a floor, right?
100% correct, Your Honor.
And the Geico cases, and I'm going to ask your opponent some of these questions the other way, but the Geico cases say that 5A5, I think I've got that right, says when an insurer receives a bill for less than the allowable amount under 627.736 5A now 1, the insurer may pay the amount of the bill, right? And then Geico's policy has language in it to the effect that when we receive a bill for that's less than the allowable amount, we'll pay the full amount of the bill, something like that.
Shall pay.
And the Progressive policy is a little bit different, isn't it?
It is, it doesn't contain any language like that.
In fact, it says we will not pay more than the fee schedules,
Correct.
which your side of this case is gonna say that's a lot like State Farm's and a lot not like Geico's, right?
Essentially, yes.
So that brings us to what I think might be a key question here, which is the way the courts, the 5th DCA and now the 4th in the Geico cases has interpreted that statute, that subsection of 627.736 is that it means when you get a BA, you still have to pay 100%. And I struggle with that a little bit because to me, does not mean shall. Generally, although it can. The 4th District told us that a few years ago. They turned out to be wrong, but they had some law under it. So help me out with that part of it.
Yes, Your Honor. That's addressed in our brief, and let me explain to you what our position is on that, and how I believe in my heart of hearts, working on this issue for 2 years, how this statute is supposed to be interpreted. Okay, and since
only 2 years,
probably longer, I'm estimating. Since MRI Associates 2, which affirmed this court came out, our interpretation of that provision has been confirmed. I would submit to you. Okay, because MRI Associates 2, if I can take a step back, says that the fee schedule is a floor, is a ceiling, not a floor. It's a ceiling, is a cap, and it's not an exclusive payment methodology. So the insurer like Progressive can still use the reasonableness methodology. So with that in place, okay, let's look at 5A5. And it's the last sentence that says if the charge is less than the amount payable under the schedule maximum charges, the insurer can pay the amount of the charge. That is a single sentence in subparagraph 5A5 of the PIP statute, which follows paragraph or subsection 1A, which as we know in Allstate versus orthopedic specialists, sets forth the non-disclaimable fundamental mandate 80% of all reasonable expenses. That is the fundamental mandate and the basis of PIP coverage. So you start with 1A and you go to 5A. Okay, which is subsumed within that mandate. It is subject to and subsumed within 1A's mandate.
And I think I can cut to the chase for you on 5A1, right? Your argument presumably is that the provider's charge shall be reasonable. That's what it says. And the provider's charge and the insurer is required to pay what's reasonable. And the provider's charge may not exceed the amount of that provider customarily charges. So here, if the provider charges less than the allowable amount under the fee schedule under either category, whether it's between 80 and 100 or under 80, then it's only reasonable. The only reasonable payment would be the amount charged, and that you use that factor, right?
Right. We accept it in full and
pay your 80%.
Charge reasonable full and pay 80%. I was working up to the 5A5. So if you look at 5A1, and again, this is in our brief, it talks about an insurer paying such charges, probably 5A before 5A1. So just because it doesn't say there in the first part of 5A, pay 80% of such charges, doesn't convert it to 100% mandate. The same is true with subsection 5. When it says may pay the amount of the charge submitted, that means 80% pursuant to the coverage mandate under 1A.
Well, I think that language could be clearer, and it would be a lot nicer if the legislature said may pay 80% or shall pay 100 or whatever it is the legislature wanted to do, but they didn't. So this is what we have. I want to ask you a couple other questions. The trial judge at the time he decided this case was confronted with precedent that I don't think would be characterized fairly as a model of clarity. He had the Geico cases, he had the Revival case with Allstate's policy language, and he had the State Farm MRI case from our court that the Supreme Court ultimately, but after the trial judge ruled, approved, but for slightly different reasons than our court supplied in its opinion. So the trial judge relied on the 5th DCA, on Irizarry, which has subsequently become the hands-on case and Moransky, and they all followed that line.
Absolutely.
And so was the trial judge wrong on that day before he had the benefit of the Supreme Court's case? And that's one question, and I know you're gonna have a big long answer for that. And or maybe not. And the other question I have for you, which is completely distinct, and I'm gonna try to shut up and let you talk for a minute, is your opponent has taken the position that your affirmative defenses, you allege that you had paid at the fee schedule, and now you're stopped to say, I don't have, or effectively, I think that's what he's saying, that effectively you can't disclaim paying at the fee schedule, at least. So if you could address those points sequentially, I'll try to be quiet and listen.
Your Honor, we submit to you the trial court was wrong, because the trial court was in with underneath the second DCA and should have followed MRI Associates 2. I'm sorry, MRI Associates 1 from this court, which was clear on the face of it that the fee schedule, or the schedule maximum charges and their fact-dependent methodology with the factors in 5A are not mutually exclusive payment methodologies under the post-2012 version of the PIP statute. We were in this district, the trial judge should have followed that law. Yes, the Supreme Court affirmed that ruling on a little bit of a different analysis, which we believe is correct and was totally consistent with what we've argued throughout this case from the trial court. So it's been borne out that yes, the trial court was wrong for not following MRI Associates 1, made exceedingly clear with MRI Associates 2.
So I'm sorry, because I gave you you answered my question on the first part, and I gave you a second question, but before you answer that, neither of you has filed this, but anybody who's reading the Florida Law Weekly has seen it. The third DCA has the same case, the Calumna case, I believe, with your insurer. I think you all were there together. Deja vu all over again today. The third DCA punted it back to the trial court so that they could consider the decision in the light of the Supreme Court's opinion in State Farm. The third was whoever the trial judge was, and the third DCA was situated the same or better as Judge Moody was here, because they didn't have any precedent. They didn't have the fifth. He wasn't, he had to choose between the second and the fourth, or the fifth, the fourth and fifth. So what, should we punt?
Please don't. Please don't. And I mean that in all sincerity. This is a huge issue across the state for insurers. The third DCA is punted. We're about to file, it's not in the record, it can be an officer of the court. We're filing our memorandum of law in that court. It's my understanding we're not even going to get a hearing until November or December this year based on the trial court's docket. This issue has to really be decided. And that's,
if we do what you want us to do we have to certify conflict with Irizarry, Moransky, and hands-on?
I think that would be prudent for one reason. The new affinity case that came out, that was the subject of their notice of supplemental authority, which I can address too. I think without that new affinity case, which was post MRI Associates 2, which I think the court just missed that decision, then I would say maybe not, because if you because your ruling will be the one post MRI Associates 2.
Let me give you the counterpoint though, on why I don't think we necessarily, if we adopted your argument. The GEICO policy is essentially the mirror image polar opposite in terms of what we will pay. We will pay 100% of a BA charge, and we will pay to the fee schedules. Progressive's policy is we will not pay more than the fee schedules, and that could be a meaningful distinction. So do you still think we have to certify conflict?
Yes, Sean, because here's the problem, and if you ask Mr. Randall, he will tell you this. He will say that Moransky, hands-on, Irizarry are all based on the PIP statute, the interpretation of the PIP statute, not the policy, and that's what we're going to hear.
Okay, so he's going to tell us about that, and I'm sorry
So
to keep jumping in on you. Please address the affirmative defense issue.
Yeah, absolutely, Your Honor. First of all, it wasn't argued under estoppel, and it could never be estoppel. To have an estoppel.
That was probably a bad choice of words on my part, but you know what he's arguing.
Let me say this, you were grappling for something to call it because there's no legal doctrine that it's under. As I said in the brief, or as you said in the brief, it's a gotcha. Well, you pled this as an affirmative defense and you're somehow stuck to it.
Well, part of what you argued in your brief, though, was that this lawsuit was based on a pretty big patient ledger. So we have a big stack of EOBs attached to your guys' affidavit. And my understanding of your argument, correct me if I'm wrong, was that by the time you got to this hearing on this motion, which was going to be dispositive, you, one way or the other, had taken out the NPPR cases and whatever else they had moved on. And that your affirmative defense, to the extent that affirmative defense was we paid at the fee schedule, it pertained to those claims, not the BA charges.
That's exactly right. So let me you got it. Let me frame it a little more finer point. So they sent a demand letter asking for additional PIP benefits on every single charge in the case. They filed a lawsuit asking for more PIP benefits on every single charge in the case.
And their complaint, the operative allegations are you underpaid and or you misapplied the deductible. So you're responding to a wholesale collection of alternative theories on a stack of bills.
You underpaid Progressive, they're alleging, every single service from May 15, 2015 through July 21st, 2015, some of which the charges were greater than the scheduled maximum charges and therefore reduced by Progressive to the scheduled maximum charges. And keep in mind, it was fluid, there's always new issues arising, you know, back at the time,
But it was
viewed that was going to be the issue.
The complaint was filed in 2015, which was before the deductible decision came out, and it appears to have been at least trying to capture that possibility.
Right, and that's when the fee schedule was still being litigated too, you know, reductions pursuant to the fee
I
schedule.
think 2015, the Allstate case hadn't come down yet.
You got about a minute before you get to your 5
Okay,
minute.
well, I can look at that. I think your Azari hadn't come out yet. That's what really tripped off the build amount issue, if you will. That's when it all got started. So, you know, Progressive's defense attorney looks at this and says it looks like a scheduled maximum charges, you know, reduction case, and raises that affirmative defense as would be malpractice not to. That's what's at issue here. They file an early motion for summary judgment, making that issue on those particular charges, which are not the build amount charges. And then the plaintiff changes its position, withdraws all those arguments, withdraws the MPP argument, and focuses on the build amount issue, which the affirmative defense saying, you know, we paid pursuant schedule has no application to. So it was never argued, it was never ruled upon. It became irrelevant. There is no estoppel, it's impossible. It's just like if you raise a seatbelt defense in an auto case, and it turns out that the person was wearing your seatbelt and the defense goes away. There's no prejudice.
5 minutes, you want to say?
Sure, if I can just finish, just thank you for
Go ahead.
it doesn't, the fact that you raise an affirmative defense that you end up not using or it's not being relevant doesn't bind you to that affirmative defense. There's zero case law that says that. That's why they cite no case law in support of that argument. And that's why you can't even figure out what to call it. It's not an estoppel because
You're gonna sit down, but I want to ask you one other question that might need addressing in rebuttal. The one thing about Progressive's policy that's troublesome here in the context of what we discussed is that it says we will determine to be unreasonable any charges that exceed blah, blah, blah. And the maximum charge is set forth in section 6273658 2A through F, which is actually the 2012 version of the statute, not the 5A1 statute. Does that change or otherwise undermine your reliance on MRI2? And you can sit down and answer it.
I can answer real quickly and say no, that's a scrivener's error. The factors are listed in there, the same factors, so it does not change the analysis.
All right, you answered the question. You got 4 minutes left.
Thank you.
All right, you're fine.
May it please the court, Matthew Emanuel on behalf of the appellee, Back on Track, LLC. Good morning. I want to first start with the discussion of the applicability of MRI6. It's the Supreme Court case affirming this court's prior ruling concerning the policy language of State Farm.
You're talking about the State Farm MRI case.
Correct. And I want to start back with this court's initial ruling that ultimately went to the Florida Supreme Court. And this court specifically framed the issue as, or the trial court did, as whether the policy language that State Farm had, a rather unique policy language, which stated a reasonable charge was defined as all the factors under section 5A and the 5A1 fee schedules, whether that was sufficient under the new 5A5 to provide notice that of its intention to limit payments to those fee schedules. And this court in footnote 1 of its decision noted that the actual payment amounts and whether they were proper pursuant to the fee schedules was not before, was outside the scope.
Well, BA wasn't an issue in State Farm. The question is the reasoning, which is we don't have two distinct methodologies. The illegal hybrid thing that is, I think, flushed out in Moransky and that is behind a good bit of your argument in the other two cases. You either have to pay fee schedules, in which case you got to pay fee schedules, or you don't. You have to pay under the factors of 5A1 and you get a jury trial. That's really what's going on in the State Farm MRI case. And what the Supreme Court said once and for all, because it hadn't been said before, is in the post-2012 statute, the fee schedules are a cap, not a floor, and there is only one for lack of a better term, methodology, and it is that you pay 80% of reasonable. And when you decide what is reasonable, you can look at the fee schedules and you can also look at the factors in 5A. So that's why we're here. And that's the argument that Progressive is making with the benefit of the Supreme Court's having said so. So we don't need to talk about whether State Farm could use the fee schedules or not. We know the answer to that. The question is, does the holding of State Farm by this court and ultimately the Supreme Court with regard to cap, not a floor, and no more hybrid, because that was a big argument that was made to this court, was illegal hybrid can't do it. If your policy is ambiguous on whether you've elected, you have to pay 80% of reasonable, which is a lot closer to what was billed about fee schedule, et cetera. Here, we now have the benefit of knowing that in determining reasonableness, an insurer can consult not only the fee schedules, but also the factors in 5A1, which include the provider's usual and customary charge, which here was less than the fee schedule. So why is it unreasonable to pay that?
Because, Your Honor, there's a distinction between generally having the ability to pay in the different methodologies, what an insurance company could do. And here, we're not dealing in the broad sense of, well, what could Progressive do if we wanted to pay these bills? It is what Progressive already did. How did they pay?
Well, they paid 80% of what was billed. We agree to that, right?
Correct.
And how is that not? Like, how does that not?
Well,
look, let me finish. How is that not paying based on the factors in 5A, specifically what the provider customarily charges? What insurer in the right mind would pay more than what the provider customarily charges? Isn't that per se reasonable?
Your Honor, the issue of what the provider charges is not essentially relevant in what we're looking at here.
It absolutely is.
Well, the issue is Progressive's payments, because you can pay under the fee schedules and you can use.
Well, Progressive, come on, we agree. Everybody knows Progressive has to pay reasonable. That's what the PIP statute says. That's what the Supreme Court says. Nobody argues.
And there's no, and just like the different methodologies are not mutually exclusive, nothing prohibits an insurance company from saying, we're just going to pay in accordance with the fee schedule and process all the bills.
But that's not what Progressive said. What Progressive said is we're not going to pay more than.
No,
it will always be unreasonable.
It's not about their policy. This is about how the initial payments and all the explanations of review that were in the record demonstrate they put notice of their payments under the fee schedule. That's it, and specifically to the insured, to the claimant, that because they're paid under the fee schedule, you're not allowed to balance bill essentially, which is what's in the statute. So that's how the claims were initially paid. Then in their affirmative defense, they don't just say they paid.
You're saying that the BA claim, the claims that were billed below the allowable amount, either 80 under 80 or under 100, that their EOBs say we're not going to balance bill.
Well, it's how they made it.
Is that what they say or not?
It's what it said. There's a notice of fee schedule. It's cited. I put a footnote in the brief of the exact language, Your Honor, and I don't want to waste time reading it, but essentially just putting them on notice that the fee schedules are being used to pay those bills. And then in this case, they took the position not that they limited payments of the fee schedule. Their specific affirmative defense in this case was that the dates of service submitted to the defendant were paid in full in accordance with the underlying policy of insurance and Florida's
and there's a comment in there, so we don't know what they were defending on, and your opponents already said, and I don't disagree with them. You had a bunch of claims in here that you were the way your complaint was pled could have been in 2015 would have been, if it had gone the wrong way for you all, or if it had gone the right way for you all in the Allstate orthopedic specialist, would have been fee schedule claims. You would have been arguing that Progressive wasn't allowed to pay at fee schedule. It was supposed to be paying 80% bill on those claims.
I'm not here to argue what would have happened if different rulings came out of court.
But the way you pled the case originally was you underpaid or because you shouldn't have used a fee schedule or you misapplied the deductible or you just underpaid. You didn't parse out which of your bills were MPPR problems, which were they shouldn't have paid out work comp because it was participating physicians or any of the rest of it. And what you wound up with were a collection of bills that were BA. And you haven't answered my question, and you can tell me if it's in the record. Are you saying that the EOBs for those particular claims indicated that they wouldn't be balance billed? And if they did, why is that a problem?
Because the EOB they stated, please be aware that pursuant to Florida statute 627, 736, 582, and 5, if an insurer elects to pay pursuant to the fee schedules found in paragraph 2, then pursuant to paragraph 5.
If an insurer pays pursuant to the fee schedule.
Correct, Your Honor, but they took, this is council's discussion of, well, we accepted it, and this is, there's no record evidence whatsoever of anything in it, there's no deposition, there's no affidavit, there's nothing filed that states that they paid any other way than according to 80% of the participating physician fee schedule.
So you don't think the affidavit that Progressive filed of its claims adjuster with the 2-foot stack of EOBs under it, that doesn't say how they paid the bills?
It does not, it absolutely does not. There is no statement in the record.
But you agree the whole problem, I mean, there's not a dispute on this. Progressive paid a collection of bills at 80% of the amount
By
charged.
applying the fee schedules, and when you.
But wait, you were talking about the bills that were paid at 80% of billed.
There's no distinction, because Progressive took the position that they paid pursuant to the fee schedules. So when you're paying.
So
under that-
this hinges, your argument right now hinges entirely on that affirmative defense, that they took the position that they paid pursuant to the fee schedules, and now you're saying, no, they didn't, they paid at 80% of the billed amount.
I don't believe you're characterizing what I'm saying correctly, Your Honor. What I'm stating is the party's position in the case where the bills that were submitted, okay, without exception, were the fee schedule was applied to those bills. So under section 5A1, those are the fee schedules that Progressive was using to remit payment to my client. And so since you're paying under the methodology, this is not talking about whether we elect to pay or we limit to pay. Once you choose to pay under those fee schedules, the sections 5A2 through 5A5, that is what governs how the proper payment should be made. And that is why section 5A5's third sentence, which deals with charges that are submitted below the fee schedule, that's why that is the statutory analysis that is before this court. It is not broadly whether or not Progressive could do something in this case, it is how they actually paid, and that is what the record shows. So if you're paying under 5A1, 80% of the participating physician's fee schedule and plaintiff's charges that fall below the fee schedule amount, what is the proper payment? So in this case, the Irizarry court, and then they confirmed and clarified hands-on chiropractic, Moransky, they specifically interpreted the statute. It's not about the policy range of Geico versus Progressive. What the issue is under the statutory interpretation, when the charge is submitted less than those fee schedules.
Well, hands-on, which purported to clarify, back up to Irizarry a little bit, says that nothing in Geico's policy or the statute allows it to pay at 80% of billed. And it also characterizes the way that Geico paid as an unauthorized hybrid payment. Looking at it through the lens of you have to go one or the other, you can't evaluate reasonableness in the context of 5A as well as 5A1, the fee schedules in 5A1. And that's a distinction.
I believe that's not what I believe if you read the first paragraph of that decision, it says when insurer chooses to reimburse under the fee schedule. So this is, again, they're not talking broadly about hypothetically how you could pay. When the insurer chooses to pay the fee schedule, what's the proper payment? So when they're addressing the improper payment in the case of Geico, they're discussing when you're under 5A1.
Is it your position that Progressive chose to pay the BA charges under the fee schedule?
The pled defense, right, the position of Progressive and how they actually remitted their payments was according to the fee schedules. And it was specific. This is not a case of Progressive saying we paid certain bills certain ways. The record is devoid of anything that counsel is relying on to make that argument.
So you're saying the Progressive purported to pay everything at the fee schedule. Then why are we here?
I'm sorry?
If Progressive paid at 80% and 200% of PPS or work comp, then why are we here?
Because that is not what the actual payments were.
The actual payments are 80% of billed.
Yeah, the payments were not made at 80% of the fee schedule, because if they paid under section 5A1 and then the provider submits charges less than those allowable amounts, then the statute tells you specifically how payments are being made. And when counsel's and the issue is what does that third sentence of 5A5 mean? And even in my associates, Supreme Court noted that the supremacy of text canon is perhaps most important, that the legislature means what it says. So when you read that,
and when it uses the term may, it usually means can but don't have to.
Correct, because there's an option. It's saying, it's not saying that you always have to pay the full amount of charge submitted. You can, or you can pay the schedule rate, 80%.
Well, it doesn't say that either. It just says may pay the full amount of the charge, period.
Well, but that's, it's specifically referencing subsection, it's specifically referencing subsection 5A1, which is 80% of the fee schedule. So it's governing how payments are made when you're choosing to pay according to those fee schedules. Otherwise, that third sentence has no effect, Your Honor, because if the insurer, like Progressive in this case, can simply pay 80% of the submitted charge, even when it's paying according to the fee schedules in 5A1, then that's.
But it's still what it says. If the provider submits charge for an amount less than the allowable amount under subparagraph 1, which is the fee schedule paragraph, the insurer may pay the amount of the charge submitted. And why isn't it a fair reading of this, given the context of this, the entire statute, the mandate of which is pay 80% of reasonable, to say if the provider submits a charge for an amount less than the amount allowed under the fee schedules, the insurer may pay the amount of the charge, or because it doesn't say shall, may pay a reasonable amount, like the charge that is what the provider customarily charges, which is what the bill was.
But the fourth and fifth DCA addresses specifically, and the interpretation of that section to add in the 80% of the amount submitted, which is not what the statute actually says, any interpretation of that would render that section superfluous. Because our common sense dictates, as those courts noted, that an insurance company is never going to pay the charge in full 100% if they could, at their option, pay 80%.
So let me take you to the other place. If just assume that we might go with your opponent's position here. Do we have to certify conflict? And if your answer to that is yes, tell me why Irizarry et al. Are not distinguishable on the basis of GEICO's policy language.
Well, you would be certifying conflict based on the specific interpretation of section 5A5, that third sentence, which was not only reviewed by just one or two panels in the fifth, but multiple panels in the fifth and fourth. So there was in total 8 different judges from the 50 CA, 9 judges from the fourth.
And to pick up on your lead there, since State Farm MRI came out, we've had several trial courts, and your opponent favored us with the decisions in the appendix to his reply brief, who have reached the opposite conclusion on policy language similar to Progressives. Why shouldn't we follow those cases? I know they're not binding, but they are all 3 or 4 different judges with the benefit of the guidance that the Supreme Court has given us, reasoning and arriving at a different conclusion with the same arguments that you're making here. Why shouldn't we follow those cases?
Well, I can tell you, since I was counsel to those cases, specifically against State Farm, that those are dealing with specifically State Farm. So there's no other, the counsel did not provide decisions from other insurance companies, and if the court, I could have provided supplemental authority as well of county court judges, but they're not.
Do you have any for Progressive or the trial judge post State Farm went the other way?
Yes, sir.
Have you filed that?
I have not filed it, but what I did file was the 50 CA's reaffirmance of their hands-on chiropractic decision on March 25th, 2022 in their fifth case. So that's from the 5th district.
So last question for you,
Yes.
maybe. Should we punt like the third did in Kalamna?
No, Your Honor, because in that case, there was a discrepancy with how certain payments were made, and there was I guess the court wasn't sure based on the record below. Specifically what payments were made for the codes and what the court could consider in light of MRI associates. Here, the record is very clear. The record is simply they took the position that they paid specifically 80% of the participating additional fee scales for Medicare Part B. And so the arguments concerning the bill amount issue of when charges are below the fee schedule, that is all that's before the court, and there's nothing else in the record that this court can really look at or rely on to show that there was any sort of disagreement between the parties or there was any issue of material fact. In fact, the parties stipulated that there were not. So if there was going to be some other type of payment methodology, or there was anything else that this court can look at to say, okay, well, we should go and reverse on that basis, it's not part of the record. So we're looking strictly at when the insurance company pays under 5A1, according to those fee schedules, what is the proper payment?
But you keep saying that they paid under 5A1, and what they paid under was 5A.
That's not what the record shows, Your Honor.
And you're relying on their affirmative defense for that?
Yes, Your Honor, because that is the only thing that articulates how their payments were made in the entirety of the underlying case. They can't abandon that defense.
You don't think the EOB that shows 80% of the amount billed is record evidence?
it doesn't, it confirms exactly what we're stating here today.
But then you're trying to have both ways. They either paid at 80% of bill less than the fee schedule amount.
They paid by applying the fee schedules to the charges, and that's not, there is no record evidence of any other type of methodology, no factors considered, no factual basis. No other various factors in section 5A, none of that was, there's no evidence whatsoever that was considered, and just because those options are available does not mean that counsel can assert here in this case that they did that.
You're down to less than 3 minutes, so if there's something else you need to add, now's your chance.
So our position, Your Honor, is that the narrow issue that's before this court is simply what are the proper payments made? Or what should proper payments be when you're looking strictly at sections 5A1, and then as the MRI Associates noted, the rest of the statutory provisions that govern what is proper payments, which are contained in 5A2 through 5A5. So
well, there is no 5A2 anymore.
No,
right? It's 5A1 A through F.
No, 5A2 through 5 are the additional provisions of the statute that dictate how the payments of the fee schedule are being made. Those are the rest of the statutory provisions that deal with the fee schedule payments. The fee schedules are articulated in section 501, yes, but 5A2 through 5 are how those are applied.
So that 5A2 tells us about which Medicare schedule and all that and all
Correct.
that. The 2007 limitation, it has nothing to do with whether the initial determination of reasonableness under 5A, which we now know is only one evaluation, not two mutually exclusive methodologies.
Correct, Your Honor, but we're still dealing with when Progressive takes the position that that's when they actually pay pursuant to the fee schedules, and when they take the position that's how they paid, then all we're doing here is analyzing under the statutory provisions were those payments proper. And the 4th and 5th DCA, there's 17 different judges have confirmed what the interpretation of that last sentence of section 5A5 means. So for this court to overturn the trial court, it would have certified conflict that the 4th and 5th DCAs and Judge Byron, the Middle District of
we're not in conflict with the federal judge.
Well, just their interpretations of an analysis of how that last sentence is applied and what it means were wrong. So if the court is going to overturn the trial court, that's what there has to be.
So you don't think Geico's policy language is relevant at all?
It was relevant to the extent that whether they always have to pay the charges submitted less than 80% of the fee schedule, always have to pay it 100%, but because they put the word shall in there, but otherwise it's optional. The insurance company, Progressive, doesn't have to. The other option is they can simply just pay 80% of those fee schedules, but they could, that last sentence is in there for a purpose, and that purpose is to prevent Progressive from ever paying more than the submitted charge by the provider. So since it's less than 80%, these are the providers, Your Honor, who are the lowest charging providers in the community. So the benefit is everyone here is winning. You have Progressive is not paying 80% of the fee schedule for that charge that's submitted so low, it's less than 80%.
10 seconds.
And then the insurer gets reduced co-payment, the provider gets paid. So there is sound logic in those courts' interpretation of how those sections apply.
That's it, you're out of time, perfect. All right, you got 4 minutes left.
You're talking fast.
I hope so. I'll be watching the clock.
Thank you, sir. We'll do our parts. Okay, so it would be, Your Honor, we would love nothing more than be able to say it here, stand here and say this is all a Geico policy problem. I will grant you that I think it's very clear that the problematic language in Geico's policy started this whole ball rolling with Irizarry and the way it worked itself up, the way it has now. But let's take a look at hands-on, and I want to tell you why this is so important that this be addressed. And if you agree with us to certify, that he referenced the initial holding, and let's read that. We hold that when an insurer chooses to reimburse according to scheduled rates, it must pay 80% of 200% of the statutorily adopted applicable fee schedule. That sentence is in direct conflict with MRI Associates 2. Here's the second sentence, which is why I'm reading this to you. There is nothing in the statutory scheme that permits a PIP insurer to limit reimbursements to 80% of billed amount. So they are interpreting
so your
the statutory
position is
scheme.
that is in direct conflict with the way that the Supreme Court interpreted 5A as being part of a unified approach to reasonableness in conjunction with the fee schedule that all the factors, A and A1. And that nothing in the statutory scheme permit, that then you look back at the statute that says, one of the factors you can consider is the charge customarily charged by that provider.
Absolutely.
Okay.
And there's a catch-all there too. But what are we supposed to do? We accepted 100% of their charges. What do they want us to say? We raise a reasonableness flag and say, thank you for your reasonable charge? I mean, come on.
Understood.
So there's nothing to be done there. But the reason I read that to you is the focus is on the statutory scheme. We need this cleaned up.
Okay, I appreciate you.
And it conflicts with MRI Associates too. And so we need this fixed.
Well, the Supreme Court will tell you whether it conflicts with their case.
We think it does, clearly. We would respectfully submit to you, and if we get to the Supreme Court.
Well, and the fifth didn't have the benefit of MRI when it wrote hands on.
I would agree. Neither did the Fourth and Moransky, neither did the federal court provide. And Your Honor, just to, I'll address this balance bill issue. There's no issue with balance bill in here.
Well, I know there isn't, but the question that I asked your opponent, and I can't get to the right answer, and maybe I'm being obtuse. If Progressive purported on the EOBs for these BA charges to be paying pursuant to the fee schedule, I think you've got something to explain.
We did. I'm baffled by it too. What's happening here?
Can you cite me to, just give me an example of one of the BA EOBs? I was hoping you were doing that.
I can, they're in the, yes, it's in my brief. I don't have that.
Okay, so you've got a cite in your brief to a record site to a specific EOB that was paid at BA, and it's going to show me that it doesn't say it was billed, it was reimbursed pursuant to the fee schedule.
Yes, Your Honors, in our reply brief where we're addressing the arguments on the affirmative defense, there's a footnote where it talks about where the opposite of what you're saying, where the charges that were greater than the schedule are. They're in the, it has the record sites for the EOBs. I think it's the last footnote.
And I'm going to look at those, and it's not going to say we paid you pursuant to the fee schedule.
No, there's a reason code for each charge, and there will not be a reason code for the fee schedule next to the charges that are issued in this case.
Okay.
Okay, Your Honor, that I can submit to you. So you understand there's no issue with balance billing. They issued a reasonable charge, we paid 80%.
No, that you
the
get
insurer
there.
goes 20%, period.
Balance billing.
Down to a half minute, so.
Down to a half minute. This whole idea of win-win-win, the insurer gets reduced copay, which is in some of the opinion. It's not a win for requiring an insurance company to pay more than it contracted for. It's not a win requiring an insurance company to pay more than what the statutory scheme requires. That's not a win. That's a loss for the insurance company. We have a contract here between contracting parties. When a reasonable charge is issued, the insurance company pays 80% and the insurer pays 20%. Period. End of conversation. That's the contract. That's the statutory scheme. I mean, quickly throw
You're out of time. You use that 20 seconds quickly.
I mean, then just say we ask that you reverse the.
Well, you both did a great job. I got to compliment you on that.
Thank you.
Thank you. Safe journeys. We'll be in recess.
Appreciate it. Thank you.
All rise.
Yes.
Thank you. Travel safely.
Thank you.